All rise. Contest for the court now session. No way presiding.
Please bow your heads for a moment of silence. Thank you, everybody. Be seated. Are the transports here yet? Are they back there? Yeah. They're here? Yeah. Oscar Fairley. Oscar Fairley. Farley. Morning.
Morning.
Commonwealth of Kentucky versus Oscar Fairley. Are you Oscar Fairley? Good morning. Were you born in 1992?
Yes.
Last four digits of your social security number 5643.
Yes, sir.
We're here for a pretrial conference. What do we have?
Well, I don't know. I made an offer. We didn't take.
If we can just get one more day on this, just one more negotiation.
What's the deal? Why do you need one more
We
day?
had this case resolved, Your Honor, and Mr. Farley's parole was revoked. And I was going to probate it. And I think then I made an offer just to settle everything 1 year consecutive. So if he wants some time to think about that, he can stay prison. I don't mind doing that.
Okay, April. No, excuse me. April the 24th. April the 24th.
Thank you.
Richard Ferguson. Richard Ferguson.
You're not custody.
Commonwealth versus Richard Ferguson, 25 CR 006. Are you Richard Ferguson?
Yeah.
Good morning. Were you born in 1968?
Yes.
Last four digits of your social security number is 0521.
Yes.
We're here today on a pretrial conference. What says the Commonwealth? Okay. Mr. Ferguson, a motion has been, I've just been informed of a motion being tendered, that says you wish to enter a guilty plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes.
Are you the same person that we just identified in 25 CO 0006?
Yes.
Is your judgment impaired today in any way?
No.
Have you discussed this matter with your attorney? Are you satisfied with his advice? Have you read the evidence the Commonwealth has against you? Are you satisfied that you're fully informed about your case?
Yes.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. I'm going to go down through the rights. You listen carefully. If you got any questions, step away and ask your attorney. At the end, I'm going to ask if you understand them, okay? You have a right not to testify against yourself. No one can make the same. You have a right to speak, trial by jury, right to be represented by counsel at the jury trial. You have to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor. And process issue to compel their attendance. You have a right to appeal this matter to a higher court if you lose. And the right to require the Commonwealth to, on a reasonable doubt, the guilty charge against you. By entering a guilty plea today, you give up those rights. You understand that? Now, I may consider Commonwealth's recommendation, but I may apply any range of sentence provided by law. If, however, exceed what you've agreed to, you can withdraw your plea and go to trial. I'm going to ask you some qualifying questions on the pretrial diversion. Have you previously been diverted in the last 5 years?
No.
Have you had any felonies in the past 10 years?
No.
Are you currently on probation?
No.
You understand if you complete the diversion agreement, the charges can be dismissed, pretrial diversion, you have your record expunged.
Yes.
You understand that if you did not successfully complete the diversion program, brought back before the court, and I revoke it, you'd be a convicted felon. You understand that?
Yes.
That can be used against you in the future.
Yes.
Ms. Gordon Anderson, what is the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to burglary third degree, the defendant shall receive a sentence of 3 years to serve. This sentence is to run consecutively with the 3-year sentence in Clinton Circuit Court, case number 25 CR 10. For a total of 6 years, pretrial diverted for 5 years. Diversion is to be supervised. The defendant agrees to enroll and complete the specialty program. The defendant shall receive credit for time served and shall be released at orientation for specialty program. The defendant shall pay restitution in the amount of $20 to be paid to Brittany Taylor. Payment in full within 30 days from the entry of this plea. The defendant shall pay the court costs at the discretion of the court.
What's the court cost?
Court cost is $190.
$190. Okay,
That's total $211.
$211. Is that what you agreed to, sir?
Yes.
Are you entering this plea because you didn't commit the acts charged in the amended indictment?
Yes.
Are you doing so your own free will?
Yes.
One of your constitutional rights, I've explained, is it's still your desire in this plea and allow the court to fix your punishment.
Yes.
Is that your signature on the document there?
Yes.
I'll accept the plea. You to remain incarcerated until you judge court to drug court orientation. When you get set up in the drug court, I'll allow you to pay your court costs and fees at $30 a month. Okay, 30 days after you get it. Okay,
Okay.
probation parole will see you up in jail.
Okay.
Okay, thank you very much. Randy Metter. Good morning. See, it's a legend's birthday today.
It is, sir.
It's on Facebook. You need my little daughter.
Okay, will do. Thank you.
We're doing that with you. Commonwealth versus Randy Metter, 19 CR 0078. Are you Randy Metter?
Sir.
Good morning.
Good morning, Your Honor.
You were born in 1980.
Yes, sir.
Last four digits, social security number 2068.
Yes, sir.
It says a motion for review on here. What does the Commonwealth have? Says a motion for review. What are we reviewing?
That's Mr. Cornwall.
That was our motion, Your Honor. We were here last month on a motion to revoke. And sent for a county case and was probated for 5 probated. And so we would ask that the time he's be treated as a sanction and that he be released and do the probation for Evans County.
I think we had the hearing on this and Mr. Metter, correct me, it was either February or March last year. I think he's been in jail about 14 months or so.
No,
He got out and come back
I got
in.
out in July, sir.
Yeah, that's right. So he got out and came back in. So I don't mind if that's what the court wants. In that way, I would just ask to take him off probation here. He's only got just a few months. He'll have 5. But if
What was the charge in Edmonson County?
this was possession of a handgun by a convicted felon, we brought the officer down here and had a hearing. And you wanted to wait until the case was resolved up there.
He pled guilty to that?
He did, Your Honor.
I can't remember any of the facts of it, Your Honor. It's been so long. I have to go back and look at the hearing.
And I should say for the court, he was already on probation in Evanston County for a 2018 case. And the judge there last Friday decided to end that probation because restitution was paid and just restart him with a 5-year probated sentence for this 2024 charge.
Why do I need to do anything on it? If he's on probate,
Well, this holder will still remain in effect
yeah.
if there is one in this case.
Is that what he's in jail on now, is the holder from here?
Yes,
Even
sir.
though the case down there is resolved.
Yes, sir.
This is
And how long has he served here?
Well, I knew we had the hearings about 13 or 14 months ago, and he was in jail, and he got out in July, and I can't remember when he went back, so he
Went back in February of this
Yeah,
year.
so he's got about 6 or 7 months.
And then prior to that, he had time, because this is a two
But
thousand
I'm just talking
nineteen.
about since the violation.
Oh, sure.
Well, I think what I'll do is I'll say that this time is sanctions. Okay, it's not a good time. Put him back on probation. I won't revoke his probation, and then when it expires, then we can pick up on the probation down there. Is that doable? Yeah, okay,
So just so I understand, so when will the probation hear end?
whenever it does.
Oh, okay, I understand.
Whenever it does, he'll remain on probation here.
Okay.
If he doesn't violate, there'll be no problem,
Yes, sir.
okay? And
Okay.
then the probationary period down there is up to him in the Edmonson County Court.
Yes, sir.
The days he served here are service sanction days that I won't revoke, okay?
Yes, sir. Thank you.
Mr. Mitter,
Yes, sir.
doesn't take very many kicks of a mule to know to stay away from it. You know, you're going free, pretty early, especially with a weapons charge. Probably wouldn't happen here, so I hope as you go forward, you value your freedom, okay?
sir. Thank you.
Okay, no problem. Travis Moles. Mr. Wright, you have some,
Good morning, Judge.
you have
Yes.
somebody that's been transported or?
No, well, Mr. Redden's here in the courtroom. from the
I'll take you
deck.
up next. I'm sorry, I didn't notice you
I
there.
just slipped in.
Being
Judge.
so quiet and
Thank you.
demure and everything.
Well,
Sitting on the wrong side over here. You notice, Mr. Stockton, where he's sitting over here?
I found an empty
Doesn't
chair.
really look comfortable there. but
Judge,
he's
I found an
sitting-
empty chair and cooking.
Okay.
Nobody ever accused Mr. Wright of being.
Caldwell versus Travis Moles. Are you Travis Moles?
Yes, sir.
Good morning, Mr. Moles. We're 25 CR 003. Were you born in 1983?
Yes, sir.
Last 4 digits of social security number 4791.
Yes, sir.
I understand that we're on a pre-trial conference. What does the Commonwealth have to say?
Commonwealth's ready for a trial date if the fence is.
Okay, what's the charge you're gonna try him on?
It's all one case. I thought it was all one case.
Charge is what?
One, endangerment, assault, DUI, domestic violence order, possession of a felon, handgun by convicted felon. So. If I could have a little time to give notice, I'll probably try the gun charge and give 404 meetings and the rest of it.
Okay. You have your witnesses out of town, witnesses or anything?
I think they're all local, Your Honor.
Okay, let's just, what about on April the 22nd, Tuesday?
That works for me.
I've got a special prosecution in Wayne County I need to go on that day.
Okay,
So last pre-trial before a trial, I need to be there.
what about the 21st?
That's gonna be our negotiation day here because of Good Friday. It's the only day we can do it.
How about May the 13th?
That'd be fine.
Yes, that's some people.
Yeah, that works for me. Your Honor.
So.
What did you talk to him about the offer?
Yes, and we made a counter for it, just wasn't accepted.
Okay.
And Mr. Moles also wants to know if the company would be opposed to a bond reduction.
Yes, we'd ask for him.
That'd be it here. Okay, let's see. On May the 13th.
Thank you.
Short.
Just draw the numbers. Okay, what's your case you have, Mr. Wright?
Yes, I had Robert Redmond, have you hired Ken here? Yes. Judge Ken messaged me that he would be about 15 minutes late, so I was hoping he would be here, but I didn't call, but I haven't seen him yet.
Okay, well, when he comes in, just bring it to my attention. We'll take it right up,
I
okay?
should not approach, this is the court file, we'll get down, this is everything, you want that.
Sure, thank you so much.
I think that's the quality is already.
Cromwell versus Jennifer Robinson. Cromwell versus Jennifer Robinson, 24 CR 0041. Are you Jennifer Robinson? Good morning. Were you born in 1986?
Yes, sir.
Last four digits, social security number 0286.
Yes, sir.
We're here for pre-trial conference. What does the Commonwealth have to say?
Felony, please, Your Honor.
As you've heard, I've been informed that you filed a motion, says you wish to enter a felony plea today. Is that correct?
Sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily made?
Yes, sir.
Are you the same person we just identified in 24 CR 0041? Is your judgment impaired today? Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes, sir.
And you view the evidence Commonwealth has against you? You believe that you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I can accept a plea, I need to know that you understand those rights. So I'm going to go down through the rights. If there's anyone you have a question about, step away from the podium and ask your attorney. Otherwise, at the end of the list, I'll ask you to understand your rights. Okay? You have a right not to testify against yourself. No one can make you say anything. Right to speak trial in a jury. Got to be rare counsel at your jury trial. Right to call a testimony. Right to produce evidence, right to call witnesses in your favor, right to appeal this matter to higher court if you lose. Right to require the Commonwealth to prove on reasonable doubt that you're going to be charged against. You understand that by entering a guilty plea that you give up all those rights. You understand that?
Yes, sir.
Okay, now I may consider the range of the recommendation of the Commonwealth, but I may apply a range of sentence by the law. I don't have to accept it range. Prior to accepting any recommendation, I will order a pre-sentence investigation report to be done by probation and parole. In the event that I do not accept the recommendation and decide to give you a harsher punishment, you have a right to withdraw your plea of guilty and proceed to trial. Ms. Gordon Anderson, what is the Commonwealth's recommendation?
Upon a plea of guilty to burglary first degree, the defendant shall receive a sentence of 10 years to serve. Upon a plea of guilty to possession of a handgun by a convicted felon, the defendant shall receive a sentence of 10 years to serve. These sentences shall run concurrently for a total of 10 years. This sentence is to run consecutive to Cumberland Circuit Court Case Number 24 CR 81. The Commonwealth will agree to probation at final sentencing. Defendant shall pay court costs at the discretion of the court. The Commonwealth will agree to shock probation in Cumberland Circuit Court Case Number 24 CR 81 upon entry to a dual diagnosis long-term treatment facilitation for a minimum of 180 days.
Is that what you agreed to?
Yes, sir.
And and because you did commit those acts is the reason you're doing that. Okay. You're doing so of your own free will, knowing your constitutional rights to explain it, it's still your desire to enter these pleas and allow the court to fix your punishment. You understand that after the entry of these pleas, any future convictions would be enhanced because of persistent felony offender status. You understand that? Is that your signature on there?
Yes, sir.
I'll accept the agreement or precincts investigation for schedule a hearing on, April the 24th.
Thank you, Your Honor.
Thank you. Okay, see Mr. Garrett has graced us with his presence. I saw him come in back there.
Yeah, we called Mr. Redmond out. I guess there's conferring. I don't know.
So she can help me.
You write the numbers down, right? Yes. Doing a special drawing for grand jury. Open court, number 54. Let's mark it. Number 67. Number 48. Number 22. Number 84. Now, those 5 people need to be marked, you know, even put back to the jury pool. But any action they take, as special grand juries, need to be earmarked so they won't be here for the trial. Okay? Okay, Adhere Circuit Court meeting in special session in Burkesville by agreement of the parties, 17 CR 006 Commonwealth of Kentucky versus Robert D. Redmond. Is Mr. Redmond here? You want to come around? Are you Robert Redmond?
Yes, I am.
What's your year of birth?
1951.
And last 4 digits, social security number 3070.
Yes, it is.
What does the Commonwealth have to say?
Judge, this case, you recall me from last time, it's been pending for several years. Mr. Redmond, his prior counsel passed away, and we've made efforts to get this back on the docket. We filed a motion, I think, for conferences and trial dates. This is Mr. Garrett's first day. We provided discovery to him. When he notified me he was in, I actually reached out yesterday to make sure he was in the case. Do you have all the discovery too? You have all that? Judge, we've made an offer that I thought was very reasonable. I don't know where we stand on that.
Judge, what I'd like to do is, got the discovery yesterday, I'd like to go through that with him and then speak with the Commonwealth. I think this is the case that will resolve. We can just set this for one pretrial conference that we'll come back and hopefully it'll resolve.
Well, you know, I hate for Mr. Wright to have to come back down here again.
I was hopeful we would resolve it today.
I've just not been to the discovery with him and I think
What's the case about?
Just, he was on probation on a drug case in Adare County. Officers went to do a home visit and found 150 various pills there. Trooper was called to the scene and collected those pills. He was indicted for trafficking for having possession. I think it was 151 pills total. 25 of them were identified as hydromorphone. So it's a trafficking, it's a possession with the intent to traffic based on statements and the number of pills that were found in his prior record. We've made an offer to amend it to possession, recommend 3 years, probated for 3 years.
would you be willing to do a year for a year?
Do what? What'd you say?
He asked me to ask Mr. Wright if he would be willing to do a year for a year.
This is not, let's make a deal here.
But Judge, I would just say.
Well, I mean, no, yeah, you know, the prosecution can meet with you, but we're not gonna get up here. I'm not in such a hurry or anything. Hand that file back down to me.
We can just have
Let's
one.
schedule a jury trial on this thing. You got the schedule up there? This thing's been going on since 2017, and you get put in a case yesterday and you want to get a continuance today, it's not going to operate.
Judge, I've not even received, I've received.
Oh,
the
well, good.
discovery
We'll set a
yesterday.
jury trial.
But I've not
And we'll
been
see you there.
Okay, what day,
Okay?
Judge?
No, what, you got the calendar there?
I have my calendar, Judge.
Okay.
Judge, I believe at this point, based on what the court has told us about setting,
Well, you can go out and talk to him for a while. I'll give you time to go
well,
over.
he's already told me that based on the court statements, he'll just do the probation.
No, I'm not gonna base anything on the court statements. I don't want to prejudice any of his rights. You go out and talk to him for a little while and see, and go over the evidence that's been presented to you. And he doesn't have to enter a plea today. We can set him a trial. He's got a right to a trial. I don't want to rush him into anything. Can you stay about 30 more minutes with us?
I can't.
Okay, won't you go out?
Judge, I don't have my laptop to be able to access the portal. I've got my phone, but I don't have a laptop.
I've got a printed copy of everything for you.
If you get him, print a copy of that. I'm not having any frustration with you.
I understand.
You
Judge,
know,
but I'm-
I mean, you're
I'm
where
just entering my appearance.
you are where you are, but he's,
Correct.
he's not gonna play me, so.
But I would just say.
It's okay. We'll give you the discovery.
In that, there's the picture. There's the.
You already did, Jennifer Roberts.
There's the officer's case.
Joshua Shaw.
There's.
Trooper, what do you have here today?
Here for a, I believe it's a revocation hearing.
You know whose it is, or?
It's on Joseph Willett.
It is, he's in Dare County Jail, Your Honor. I told the trooper when we got to Dare County Jail.
We'll do you first when we get there to Dare County Jail. Are you Joshua Shaw?
Yes, sir.
Good morning. We're on 25 CR 004. Mr. Shaw, were you born in 1993?
Sir,
Last four digits, social security number 3558.
sir.
Okay, we're here on a pretrial conference. What's Commonwealth?
Well, Commonwealth's ready for a trial. Tennessee, Your Honor.
Okay, what's the charge you're gonna try?
It's a burglary breaking into a camper. The victim wants prison time. Look, based on Mr. Shaw's criminal history, I'm not gonna overrule the victim in this case.
Yeah. Think this will be a one-day trial?
One day.
Okay. Well, we previously scheduled one for May 13th. We could do this one for May 14th. That way the jury could come in for 2 days.
That'd be fine.
Okay. That's on a Wednesday. So, what we'll do is we'll come up and let's start at 8:30. And that way we'll try to seat the jury and then we'll probably move downstairs.
That's fine. Better make it know what's on.
Dennis Spears. Commonwealth versus Dennis Spears. 24 CR 0088. Are you Dennis Spears? You born in 2002. Last four digits, social security number 5424. We're here for a pretrial conference. What does the Commonwealth have to say?
Felony plea, Your Honor.
Okay. Just been informed that you filed a motion, says you wish to enter a plea today. Is that correct? Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given? Are you the same person we just identified in 24 CR 0088? Is your judgment impaired today in any way? Have you discussed this matter with your attorney? Feel like you're fully informed about your case? You need to speak up a little bit. That is a microphone. That microphone is voice activated, so the camera's not on you unless we can hear you, okay? Have you viewed the evidence the Commonwealth has against you?
Yes, Your Honor.
Do you believe you're fully informed about your case?
Yes, Your Honor.
Okay, you understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. Prior to accepting a plea, I need to know that you understand those rights. You have the right to speedy trial. You have the right not to testify against yourself. No one can make you say anything. You have the right to be represented by counsel at your jury, right to confront the trial, to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, right to call witnesses in your favor, right to appeal this matter to a higher court if you lose, the right to require the Commonwealth prove on a reasonable doubt that you're guilty of charges. You understand that by entering a guilty plea today, you waive all those rights. You understand that?
Yes, Your Honor.
I may consider the Commonwealth's recommendation, but I may apply any sentence allowed by law. I do not have to accept the recommendation prior to consider your recommendation. I will await the pre-sentence investigation report to be done by probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea and proceed to trial. Ms. Gordon Anderson, what is the Commonwealth's offer?
Upon a plea of guilty to assault second degree, the defendant shall receive a sentence of 10 years, serve 9 months, balance probated for 5 years. Probation is to be supervised. The defendant agrees to be assessed and follow any recommendations of the social services clinician. The defendant agrees to enroll in complete anger management. The defendant is to have no contact with the victim, and the defendant shall pay court costs at the discretion of the court.
Is that what you agree to?
Yes, Your Honor.
Are you pleading guilty because you did commit the acts charged in the indictment as amended?
Yes, Your Honor.
Okay, are you doing so of your own free will? Knowing your constitutional rights to explain to us, it's still your desire to give up these rights by entering a plea of guilty and allow the court to fix your punishment within the range permitted by law.
Yes, Your Honor.
You understand that after entering a guilty plea today, any future convictions could be enhanced under persistent felon offender law.
Yes, Your
Is
Honor.
that your signature on there?
Yes, Your Honor.
Okay, I'll accept the plea order of pre-sentence investigation report schedule sentencing for April the 24th. Okay, thank you very much. Jamie Stearns. Jamie Stearns. Is this the last one you have? Okay,
Your Honor, I have his agreement here, but I haven't had a chance to go over it with him and have him sign it. I just have a
so why don't
moment.
you step back in there and go over it with him?
Thank you.
Okay, I'll go into the out of custody docket here. I'll take one of Miss Costello's cases because he's back there.
Okay.
Dwan Maxey for sentencing. Yeah, this pre-sentence investigation report. Are you Dwan Maxey?
Yes.
Good morning. Morning. You're 24 CR 0066. Mr. Maxey, were you born in 1969? Last 4 digits, social security number 9653. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole? Is it substantially correct?
The only corrections, Your Honor, are something we can do with probation and parole. His children were left off on the family history, or 3 of his children were. So we'll add those to
How
probation.
many children does he have?
4. 1 was on there and 3 were missing, so we'll add that.
Is there anything else?
No, Your Honor. I apologize. One more correction. He's listed as having 3 days of jail credit, but he has been on, hooked up on his ankle monitor since I believe the 7th, and that wasn't being calculated. And he has to do 90 days of home incarceration, Your Honor, so he has started.
I'll count those days.
Thank you, Your Honor.
On a plea of guilty to trafficking and controlled substance first degree, the defendant shall receive sentence of 5 years, 90 days in home incarceration, balance probated for 5 years supervised. What's the court cost?
$440.
$440. You need some time to pay that? Yes. You pay it $60 a month, first payment being 30 days from today, okay?
Yes.
You need to step over there and talk to probation parole officer.
Thank you, Your Honor.
Yeah. You have anything else, Ms. Costello?
Your Honor, I was Matthew Bradley for sentencing to the Adhere County Jail and
Okay, we'll
Crystal
wait.
Gerald's in the courtroom.
Commonwealth versus Crystal Gerald's. Commonwealth versus Crystal Gerald, 25 CR 0002. Are you Crystal Gerald? Okay. Good morning.
Good morning.
Were you born in 1980?
Yes, sir.
Last four digits, social security, 1147.
Yes, sir.
We're here on a pretrial conference. What's the Commonwealth have to say?
Your Honor, there's some other issues going on. Can we have another pretrial conference in this case?
You want a negotiation date?
Yeah, that'd be good. On
What is the negotiation date?
April the 21st at 9. If Ms. Costello can't be there, we'll talk the phone.
April 21st at 9 a.m. and the next court date's April 24th. Both of them are conditions of your bond. You understand?
Yes, sir.
Okay,
Thank you, Your Honor.
yeah. Gene Parrish. Here's Mr. Parrish has an active warrant for him, Mr. Stockton. Okay, you want to put NCIC? Tell them we're ready for it. Are you ready on Jamie Stearns?
Yes, sir.
This is Commonwealth versus Jamie Stearns, 23 CR 0098, 23 CR 00105, and 24 CR 0044. What does the Commonwealth have to say about Jamie Stearns? Mr. Stearns, you were born in 1977.
Yes.
Last four digits, social security number 4748.
Yes.
I've just been informed, as you heard, that you filed a motion to enter a guilty plea. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No, Your Honor.
Is this plea freely and voluntarily given?
Yes.
The same person we just identified in those three cases,
Yes.
three indictments. Is your judgment impaired today in any way?
No, sir.
Have you discussed these charges with your attorney and are you satisfied with his advice?
Yes.
Have you reviewed the evidence Commonwealth has against you, believe you're fully informed about your case?
Yes.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I can accept a plea of guilty, I need to know that you understand those rights. Okay?
Yes, sir.
I'm gonna go over, if you have any questions, straight forward from the podium. Ask a question. You have a right not to testify against yourself. No one can make you say anything. Right to speak trial with jury, right to be represented by counsel at the jury trial, right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in their favor. Right to appeal this matter to higher court if you lose, right to require the Commonwealth prove beyond a reasonable doubt that you're guilty charged against you. Understand that by entering guilty plea, they give up those rights. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, but may apply a range of sentence provided by law. I do not have to accept any recommendation. Prior to accepting any recommendation, I'll await the pre-sentence investigation report, probation, and parole. In the event that I do not accept the recommendation, the Commonwealth will decide that impose a harsher sentence. You have a right to withdraw your plea of guilty and proceed to trial. Do you understand that?
Yes.
It's Gordon Anderson. What is the recommendation of the Commonwealth?
Upon a plea of guilty to possession of a controlled substance, first degrees, 2 counts, the defendant shall receive a sentence of 3 years on each charge to run concurrently for a total of three years to serve. This sentence is to run consecutively to Cumberland Circuit Court case numbers 23 CR 105 and 23 CR 98. A 5-year sentence for a total of 8 years, probated for 5 years. Probation is to be supervised. The defendant shall receive credit of 134 days as a sanction. The defendant shall be released on home incarceration at the entry of this plea until orientation for specialty program. The defendant agrees that the probation in case number 23 CR 105 and 23 CR 98 shall be extended for a period of 5 years from the entry of this plea. The defendant agrees to enroll and complete the Cumberland County Specialty Program. The defendant shall pay a fine and court costs at the discretion of the court. The defendant shall obtain gainful employment or do 30 hours per week of community service until gainful employment is obtained. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the laws of the Commonwealth of Kentucky, and the defendant shall remain on active supervision until any and all fines and court costs are paid in full and until further request of probation and parole. There was a charge that was dismissed. It was the possession of a firearm by a convicted felon. And the reason is because there was a co-defendant. She said that it was her gun and it was found in her residence. So that's the reason why that charge is not going to be pursued.
Is that your
against Mr.
understanding of the Commonwealth's recommendation?
Yes.
And Ms. Gordon Anderson, I'm not real fond of releasing him prior the drug court orientation. That's not our practice. You say, well, why are we doing that?
I'm not for sure, Your Honor.
He has some health issues. I think he has a
Well,
surgery.
You don't need to state in open court what his health issues. I respect his privacy somewhat. But I'm not inclined to do that. When is it, he's already been voted into drug court?
No, we've not been assessed yet.
See, I mean, he hadn't been assessed, he hadn't been voted in, and he's not been oriented, and they won't me to let him out till then.
With approach.
Yeah. I know how to do this. Wait a second.
Okay.
You know, I would like to be able to do it myself, but I don't see it. It's usually on this screen here, and it's not.
I think it works there.
Let's see. You gonna bring him up here too? He's got a right, no, we're not talking behind his back.
It's nothing bad. The reason I agree with this is for that Thomas J. Brown is gonna have to have Steve's thickness hard when he's trying to get him out so he can go to the doctor.
When you got that scheduled yet?
Yes. Supposed to be 6 weeks ago, but I've got to get my insurance back where I'm on disability. So I don't know how long it takes, but because they meet,
Where are you gonna be living up with that shit?
301 Spencer Street.
It's here in Burkeville.
Yeah.
Who's there? Who lives there?
Nobody, it's gonna be me.
Yeah. Well, you look better since you've been in jail than you did once you've been out. You know what, probably why you have an extension in your heart, and drugs probably do.
Completely sad. Trying to do that.
Okay, I'll go along with it, but I'm gonna tell you what, don't you spit on the sidewalk while you're there. Okay,
But that's the reason.
okay, let's go back up. Okay. I'll accept the medical explanation that you gave for the record.
Thank you, sir.
Okay. So this plea of your own free will,
Yes.
you know, your constitutional rights, is it still your desire to give up those rights, enter a plea, and allow the court to fix your punishment? I have a pre-sentence investigation report done by probation and parole. We'll come back here for sentencing on April the 24th. Set your signature on the document.
Yes, sir.
Okay, what are the court costs?
Yes, it's $160.
Okay, but considering your medical issue that you have, everything, I'm gonna waive your court costs on the thing. So you need the probation and parole officer over here. Fifty-three. 35. No, it didn't change. No, we're back on the out of custody docket, correct? Mr. Wright, do you have anything to report in your case?
I think we're going on with the paperwork now.
Okay.
A lot of what we did, I think we got it.
All right. William Brooks.
Morning, said his car broke down. Just fine.
Okay, issue an arrest warrant for Mr. Brooks. And we'll know where to find him next time. Right? No bond, no Mr. Brooks. Are you Brandy Franklin? Good morning. 22, Commonwealth of Kentucky University. Brandy Franklin, born street number 0412. Okay, you here today for the purpose of attorney? You look at advocacy, and then I want to affidavit that on her. Just Cumberland County's returned an indictment charging possession of controlled substance first degree. You understand that, Mr. Bailiff? The identity of your client counsel. Are you Angela Guerra?
Yes, sir.
This is 24 CR 00003 today, here today for sentencing. Ms. Guerra, were you born in 1972?
Yes, sir.
Last four digits, social security number 9980.
Yes, sir.
And you had an opportunity to look at the pre-sentence investigation report done by probation and parole.
Yes, sir.
Is it substantially correct?
Yes.
Counselor, is there any reason so you should not be sentenced today?
No, Your Honor.
On plea of guilty possession of controlled substance, first degree, defendant shall receive a sentence of 3 years. Probated, however, for 5 years, probation is to be supervised. On plea of guilty operating a motor vehicle under the influence, defendant shall pay a $300 fine and serve 7 days in jail. Does she have any days in yet?
Yes, Your Honor. I believe she has well over 7 days.
What are the court costs?
$980.
$180, okay. Well, I need to see somebody check, see if she's got her 7 days in, see if she can leave today. She does, okay. You need some time to pay the $980?
Yes.
Okay, I'm gonna allow you to pay it $50 a month.
Okay, thank
And
you.
the first payment will be due 30 days from today, and every
Okay.
30 days until that is paid. Now, when you pled guilty to the DUI and to the felony, they informed you that they were enhanceable, is that correct?
Yes,
If
sir.
you had another felony, it would be PFO,
Yes,
it would be enhanceable, more serious crimes, is that correct?
yes, sir.
Okay, well, you need to go over and meet with the probation parole officer over there, and you'll give us some information.
Thank you.
Okay, thank you. Amber Melton. Amber Melton. Commonwealth of Kentucky versus Amber Melton. Are you Amber Melton?
Yes.
Good morning. You born in 1993. Last four digits social security number 1724. This is 25 CR 0008. We're here today on the pre-trial conference. What's the Commonwealth have to say?
Pre-trial version, please.
Okay. I'm just informed, ma'am, that you wish to enter a plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given? Are you the same person that we just identified in 25 CR 0008? Is your judgment impaired today in any way?
No.
Have you discussed these charges with your attorney? Are you satisfied with the advice of your attorney? Have you viewed the evidence the Commonwealth has against you? You believe you've been fully informed about your case? You understand you do not have to enter a guilty plea that you have certain rights under the Kentucky United States Constitution. Before I accept the plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make the same thing. Your right to speak trial by jury, your right to be presented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, the right to call witnesses in your favor, have process issued to compel their attendance. You have a right to appeal this matter to higher court if you lose, your right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. Understand it, but in a guilty plea, you can give up those rights. You understand that?
Yes.
I may consider the Commonwealth's recommendation, but I may impose a sentence harsher by doing you can withdraw your plea and proceed to trial. Now, I have some qualifying questions that I want to ask you. Have you previously been diverted in the last 5 years?
No.
Do you have any felonies in the last 10 years?
No.
Are you currently on probation? Are you currently on probation?
Yes.
Okay, what are you on probation?
district court probation.
For what?
That wouldn't work, that you're not probation.
She's not eligible even if she's on district court probation, is she? Statute says probation, it doesn't say circuit or felony.
That's something I've never run into.
Well, why don't y'all take a look at it, we'll call her back.
It'll be up to Judge Costello, where she wants to stay.
Pardon?
Judge Costello will know more about that case than us, so it'll be up to her probably.
Well, I just want to know what the statute says, if you're willing to accept whatever it is.
Yeah, I'm willing to do whatever.
But I just want to make sure that she's statutorily eligible, is what I'm saying. So you look at the statute and see if it says felony probation or probation.
You know, if we proceed that she's not eligible, then we'll come back for other arrangements, I guess. Or
Have you got the statute book here?
I don't know if it's a statute or a regulation.
It's a statute. I've got one here if you want, this is a book here. I know y'all don't use books, but right here on top, reach over here. This green book here. I'd be like Dave Sharp when he went over to Marybone and asked the guy if he had his reading book, and the kid said, "Is that the red one?" So, if y'all look that up book for a second. We can come back to that case if you want to, give you a second. Do that. You'll have a seat back there. Mr. Ryder, you ready to go?
We are, Judge.
You have the file back. I heard Miss Corbin's boss, sir. I had to get on. That's what it is. It's been in bad shape for several days now. Commonwealth versus Robert D. Redmond. Again, this is the Dare Circuit Court meeting in special session by agreement in Burkesville. We've previously identified you, Mr. Redmond. Have we all reached an agreement now?
We have, Judge.
Okay. A motion's been tendered that says you wish to enter a guilty plea. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
Oh, no.
Is this plea voluntarily given?
Yes.
Are you the same person we just identified a few minutes ago as 17 CR 0006? Is your judgment impaired today in any way?
Yes, Your Honor.
Have you discussed it is not impaired?
Is your judgment impaired today?
Yeah, I thought you said yes. I don't know. Have you discussed these matters with your attorney? Are you satisfied with his advice?
Yes, sir.
You read the evidence for a while the Commonwealth has against you. Are you fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky United States Constitution. Before I can accept the plea, I need to go over those rights with you. At the end, I'll ask you if you understand them, okay?
Yes, Your Honor.
You have a right not to testify against yourself. No one may say anything, right to speak, trial by jury, right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor. The right to appeal this matter to higher court if you lose, the right to try the Commonwealth prove beyond a reasonable doubt that you're guilty of the charge against you. Understand by entering a guilty plea today, you give up all those rights. You understand that?
Yes,
Now, I
sir.
may consider Commonwealth's recommendation, but I may apply a range of sentence provided by law. I do not have to accept any recommendation. Prior to accepting any recommendation, I'll await the pre-sentence investigation report done by probation pro. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have a recommendation, Mr. Wright.
Judge, again, we're gonna amend it to discuss first degree. Present ours.
Okay.
That would be.
Okay. Are you pleading guilty because you did commit the acts in the indictment as still your desire to give up those rights, enter guilty plea, allow the court to fix your punishment or the range permitted by law? Okay, saying that after any guilty plea, any future convictions that you might have. Is that your signature on the offer there? Except order pre-sentence investigation report. Now, and we'll have your sentencing on April the 24th. Mr. Wright, you can attend by Zoom if you would like. Okay. Our client here, however, in person.
Tomorrow will be fine, Judge.
April 24th. And Mr. Wright will, so if you have any discussions you have with Mr. Wright, you need to call him beforehand, since he's gonna, it's a long drive from Casey County. Yeah. Mr. Bailiff, will you include that in there and hand Mr. Wright? We have,
Judge, can we be excused?
yes, now, he needs to meet with the probation and parole officer here. Wait just a second, sir. Talk to the probation and parole officer.
Just, you, here's the clerk will deal.
We'll type you one up there. She, are you fixing one back, an order back there? We type all the orders and,
It's okay.
you know, what it says.
If did you want me to wait to get that, take back?
She operate right out here.
Very good. Judge,
Or you can take it, and change going back there and try to rush her, either one you want to. I see I just away like that.
I'll wait.
I'll send it to Adair County when I get it done.
James Riley.
It's just.
Commonwealth person, are you James Riley? Mr. Poindexter represents you, doesn't represent you. Public advocate, public defender. Okay, this is 24 CR 0094. Mr. Riley, you born in 1959.
Yes, sir.
Last 4 digits social security number. 8554. What does it say? What do you have on James Riley?
Have a felony plea, Your Honor.
Motion been tendered, Mr. Riley says you wish to enter a plea today, is that correct?
Sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
This is please freely and voluntarily given.
Yes, sir.
Are you the same person named in 24 CR 0094?
Yes, sir.
Have you discussed this matter with your attorney? Are you satisfied with his advice? Have you viewed the evidence the Commonwealth has against you? You believe fully informed about your case? You understand you do not have to enter a guilty plea today, you have certain rights. And did you call back there and see if Megan heard me? You have certain rights. Before I'm gonna go over those rights, and if anytime you can step away and talk to your attorney, you have a right not to testify against yourself. No one can make the same thing. Right to be trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all that's called to testify against you. Right to produce evidence, right to call witnesses in your favor, right to kill this matter, hire court to lose, right to prove Commonwealth without a reasonable doubt that you are guilty of charge against you. Understand that by entering guilty plea today, you give up hope. You understand that? Today, upon each sentence provided by law, I have to accept the recommendation. Prior to accepting the recommendation, I will await a pre-sentence investigation report to be done in probation. Do not accept the Commonwealth's recommendation and decide to impose a harsher sentence. You all your plea and proceed to trial. Do you understand that? Mr. Stockton, what is the Commonwealth's recommendation?
Your Honor, Mr. Riley will plead guilty to possession of controlled substance first degree. He will get a 3-year sentence, probated for 5 years. Obtain gainful.
Is that what you agree to? The acts, to committed acts. You know, constitutional rights is to your desire to. Guilty plea to any future convictions will be enhanced on the procedure. Felony matter.
Yes, sir.
I'll agree, accept the agreement or and it was a probated sentence, right?
That's correct.
I'll, order pre-sentence investigation. 24th, if you will go over there and meet with the probation parole officer, okay? Okay, in the middle of Amber Melton, is that correct? We'll take that back there. Amber Melton is here on 25 CR 008. Miss Melton, we were down through these questions and I asked you if you know. We didn't go through the statute and that does not disqualify you, okay? You understand if you complete the diversion program, the charges will be dismissed, pre-trial diverted. However, if you violate the terms of the pre-sentence investigation, avoid that, you get convicted felon that can be used against you in the future. You understand that? Are you because you did commit the acts as in the amended indictment? You're doing so of your own free will. Know your constitutional rights to explain it. I give up those rights and plead guilty and allow the court to fix your punishment. There's your signature. I accept the agreement, signed in the diversion order. You'll still need to go over and talk to the probation parole officer over there and give him certain information. What are the court costs in this case?
Oh.
It's Amber Melton.
She.
Maybe we read the plea. Do we read the
Go ahead, go ahead.
Upon a plea of guilty to possession of controlled substance first degree meth and possession of controlled substance first degree opiates, the defendant shall receive a sentence of 3 years on each charge to run consecutive for a total of 6 years, pretrial diverted for 5 years. Diversion is to be supervised. The defendant has served 72 days. The defendant agrees to serve 120 additional days home incarceration. The defendant shall pay court costs at the discretion of the court. The defendant agrees to enroll and complete the Cumberland County Specialty Program. The defendant shall obtain gainful employment or do 30 hours per week of community service is obtained. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the laws of the Commonwealth of Kentucky. The defendant shall remain on active supervision until any and all fines and court costs are paid in full and until further request of probation and parole.
Is that what you agreed to, Ms. Melton? When, are you on a monitor now, ankle monitor? Well, we'll need to get you hooked up. Who's doing that?
Judge, she's talked to Junior Smith, and I think he's gonna do it, take care of it.
When?
He's gonna get you installed.
Yeah, I can meet up with you today, you know.
Okay, well, it should be, hook up with it about 4 o'clock today. I'll give you the time. Okay,
The judge, with the home incarceration, is Mr. Smith, does he have discretion for, because she's gonna need work release? Her job, she's starting tomorrow.
where are you working at?
EMK.
Okay, well, I'll allow our work release on that. And you also can go to church from there and to the doctor. Do you have children?
Yes, I do.
What kind of school things are they?
Baseball.
Okay, well, I'm glad you're going to go to baseball. I think that's just as good for you as a doctor.
Thank you.
Okay, now you're gonna need to work with these people and come off with whatever issue that you had. You're still a young person. You got a great life out there in front of you. How many kids you have? 4. Well, they need you, and I don't want to have to send you to prison. It's not my goal, not Mr. Stockton's goal, any of our goals when we come here. We don't relish that, but I will send you if I have to. You understand? Okay, you meet with the probation parole officer, and Mr. Gar, you report back to Commonwealth that she's hooked into the Commonwealth
Yes, I
Attorney's
will,
office
Your
and she's hooked up. Okay,
$260.
how much?
$260.
$260. Start paying at $30 a month. First payment 30 days from today. And when you meet with the drug court,
She, the order will be, and she might be able to get it later.
it wouldn't be bad if you sit on the office on the way out, Mr. Garman, you know where Mr. Murphy's office is
Yes,
right there. Hey, if he's in there, check in with there so we won't have any glitch there.
Great. Thank you, Judge.
Okay, Christopher Melton. Christopher Melton. Cromwell versus Christopher Melton, 24 CR 0092. Are you Christopher Melton?
Yes.
Born 1968.
Yes.
Last 4 digits, social security number 0095.
Yes, it is.
We're for sentencing today. You understand that?
Yes.
You had an opportunity to look at pre-sentence investigation report number probation parole. Is it substantially correct?
Yes, Your Honor.
The reason why this gentleman should not be sentenced?
No, Your Honor.
On a plea of guilty to possession of controlled substance, first degree offense shall receive a sentence of 3 years probate, 5 years supervised, plead guilty of operating another motor vehicle. The defendant shall pay a fine of $300 to serve 7 days in jail. Does he have his 7 days in?
No, Your Honor.
Okay. Defendant shall pay, I'll give you, what's the total on
$580.
$980? I'll allow you to pay that at $50 a month, first payment, 30 days from today.
Okay.
Hey, you're in the custody of jailer.
But he also said, he put guilty to leave out last month. He can file a hardship lawsuit. He's also about that.
I don't know anything about a hardship license. There's the application for a hardship license. Where do you work?
EMK.
Yeah. Okay, well, I'll let him have a hardship license to go to work.
Okay, I
appreciate that
very much.
Do you live by yourself or?
Well, I take care of my mom right now.
Okay, well, how old is she?
Forward.
You the only person that lives with her there?
Yeah.
Okay, you can go to work, you take her to the doctor, anybody go to the grocery store for you?
No.
Okay, well, you can go to the grocery store.
Okay.
So you go to work, church, take your mom to the doctor and go to the grocery store. That'll allow you to function. But now don't you let me down on this thing.
I promise you that.
Okay. You need to meet with probation parole officer. Ashley Stotts. Is there anybody else out there whose name I hadn't called that's supposed to be here today? Raise your hand. Cromwell versus Ashley Stotts. Those of you that are online, we're coming to you right now, okay? Cromwell versus Ashley Stotts, 21 CR 00150. Are you Ashley Stotts?
Yes, I am.
Born in 1984.
Yes.
Last 4 digits, social security number 8511.
Yes.
Okay, pre-trial diversion revocation.
Your Honor, Ms. Stotts is on diversion for failure to making false statements as regards to benefits. She has tested, had positive for marijuana. She was in possession of multiple marijuana things such as vapes and things like that. She had went to the Kentucky Cannabis Clinic and got a statement saying she's eligible for medical marijuana. The problem is that's if you comply with the statute, you've got to get that statement. Plus then you've got to get the cabinet, the appropriate state agency to issue a card so you can use that and buy the marijuana from an approved dispensary. You just can't go out on the street and buy what you want. And she's kind of jumped the gun on this. She's went ahead and purchased stuff when she's not been allowed to on probation. And even though she may have a medical necessity, she's not went through the proper process.
What is a period of her diversion for what?
5 years.
For what? For that?
For falsely applying for benefits, yes.
And it's paid for, okay.
The restitution's been made, yeah.
Everything's.
But we can't have, this thing's gonna get out of control if we just let everybody's on probation, get it.
So that they're eligible for it.
Say they're eligible and they don't go through the
Are
process.
you working now?
I am.
Where are you working?
Tolson's, third shift, I work 4 years a week. Everything else has seemed pretty good, just this has been a problem over and over and over. And medically, they checked it out and it is legit. My doctor saw them 2 different times.
Well, I don't know if you're understanding, Ms. Stotts, or not. It's,
Okay, let me explain it to you. Your doctor is not the judge or the prosecutor. The legislature, whether it's good or whether it's bad, has established a process where people can get a medical marijuana card. And if they get a medical marijuana card, they can't go out here on the corner and buy marijuana. They have to buy it from an approved source. And the reason they do that is so people won't get out and buy dusted up stuff. You understand what I'm saying? So you're no different than anybody else as far as compliant, except you might be a little slicker than most people. And you'd also work, which makes you one of a few that comes in here that's working. I will say that. But I'm not going to revoke your pretrial diversion, but I'm going to give you a sanction. Okay? Do you work on the weekends? Okay, I want you
Sunday
to
night through Thursday.
do what?
Sunday night through Thursday night.
Okay, so what I'm gonna do is I'm gonna give you the next 3 weekends in the Adair County Jail. You're gonna come in, go in by Friday at 6 o'clock and you get out Sunday at noon. Okay, and you're still gonna be on a pretrial diversion. You're not gonna be a convicted felon or anything because you're working and I believe you're trying. Okay, so you turn yourself in up there tomorrow at 6 o'clock. Is that okay with you? The Commonwealth, is that seem
That's
appropriate?
fine with me and I just want her to comply with the rules.
Now you know what the rules are.
No, that's the problem. I don't have a definition of what the rules are.
Well, I'm
about
just
the
telling
medical.
you what the rules
Well,
are.
I got a medical certificate at the time because that's all they had available.
Okay, well, it's not my problem. My problem
Why
is.
do they accept the
okay,
box? And
What you got to do is find out what you have to do to comply and comply with it.
can I ask a question, please?
Absolutely. I wouldn't want to deny the
Okay.
objection.
I just want to ask how that you accept, how you all make it legal from other doctors to accept other prescriptions of other people on pretrial diversion and probation. And because it's medically necessary, I did obtain those
when I purchased, I got them I drove out of state to a dispensary. They weren't just off the street from a local drug dealer. I showed receipts. I didn't have them in my possession. I was never caught with them in my possession. That's what the certificate was to protect me for. I figured this would happen. My doctor foreseen it happen too. But I just wanted to add that
There's
to
a
it.
difference between marijuana and all of the prescription drugs for whatever.
But if you use the lotion, pain.
I'm not gonna argue with you about what the law is.
I'm sorry, I'm not arguing. I'm just
Well,
explaining.
well, what I'm telling you is you need to consult with your attorney to make sure you're in compliance, and I'm not revoking you.
Yeah. But I just want to get on the same page with this because how can they?
My page is that it's your page. It's not my page. It's not Mr. Stockton. It's okay. Thank you very much.
Thank you.
Judge, you might swear in with grand jurors.
Yeah, bring your grand jurors around. Wants to step down. We just got two. I thought we needed three.
Me too.
Well, congratulations. Thank y'all. You raise your right hand. You solemnly swear or affirm that you will do your duties as the grand jury of Cumberland County. That you will hear all the evidence that is presented there, that you keep all matters confidential, you will protect and defend the Constitution of the United States of America and Commonwealth. Do that. Thank you very much. You go with them, okay? Okay, let's go to Boyle County. Okay, I'll get to them. I'll try to do that. Thank you. We'll do Boyle County. Are you on the line here? This is Commonwealth Kentucky versus Caitlin Riddle. Is that correct? Caitlin Riddle. Are you Caitlin Riddle? Turn that microphone on. You see that little red dot? Looks like a microphone. You need to push that there. Somebody needs to help you turn the microphone. There
Can you hear me?
Now it's on.
Okay.
I can. 114, Caitlin Riddle, a pretrial diversion of Commonwealth had to say. Commonwealth had to say.
Your Honor, she been died in Mercer County. Publicity on, she was in a car, had 30 grams of methamphetamine. So, I mean, the court wants me to bring the officer down here. I was just gonna wait and see if she's convicted on that or not.
Okay, we'll continue this case, and you need to put it on the docket for some time out in the future.
Yeah,
You want to redocket it
I'll
yourself?
just redoct it once that case is disposed of.
Okay, Ms. Riddle, they're gonna see what happens to your case up there in Mercer County, and then they'll decide what they're gonna do here, okay? Thank
All
you
right.
very much. Thank you very much, Boyle County. You may be excused. Let's go to the Adair County Jail. Can you hear me better now, Adair County? Somebody cut disconnect. Boyle.
Yes, Judge, I got you.
Okay,
Okay.
Get Joseph Willis first.
that's what we're gonna do.
Okay.
Okay, Adair County, you want to turn your microphone on? We want to call Joseph Willett.
Will it? Brandon, pull the door shut.
Chris is over.
Commonwealth versus Joseph Willett, which would be 22 CR 0040. Are you Joseph Willett?
Sir.
Born in 1984.
Yes, sir.
This is social security number 1455. What does the Commonwealth have to say in this case?
Your Honor, this is a motion to revoke pretrial diversion. He's on a 3-year sentence, possession of a controlled substance. On February 18th, 2024, he was arrested in Washington County for possession of a controlled substance, first degree, operating a motor vehicle under impairment, also multiple traffic violations, and will probably be charged with assault third from that incident also.
Okay. Y'all want to stipulate or what?
Well, with that charge, they released him to ARC, and I think he's doing a lot better.
I can't hear what you're saying.
Oh, I said with that charge, he was released to ARC recovery. And I think he's doing a lot better with his
I'm
substance
not
abuse
asking
problem.
whether he's doing better or not. I'm asking you what you want to
Yes,
stipulate to these things that happen.
Yes, I do want to stipulate.
Now, what's Commonwealth's?
I want to ask, based on the charges, he was DUI plus he got into altercation with the officer had to wrestle him over a bank and everything. I'm asking his diversion be revoked except for final sentence.
Okay, will, anything you have to say about the case can be addressed at the sentencing.
Yes,
So
sir.
I'm gonna revoke his pretrial diversion and set, order pre-sentence investigation report and ask that he be sentenced on April the 24th, and your attorney will be to see you, Mr. Willett. And anything you have to talk to about what happened since then, be taken care of. Thank you very much. Thank you for your attendance, officer.
Go ahead.
Okay, Scott Barlow.
Barlow. Willett.
Commonwealth versus Scott Barlow. Are you Scott Barlow?
Yes.
Good morning. You're here today for the purpose of arraignment in 25 CR 00016. Were you born in 1971, Mr. Barlow?
Yes, sir.
Last four digits, social security number 1542.
Yes, sir.
Okay. Okay, I'm going to continue the appointment of the Department of Public Advocacy. You have a right to remain silent. Your attorney is present here today. Just say something and see if that microphone is switch over to.
Hello. Hello, Mr. Barlow.
See, there you go.
Hey, how you doing?
The grand jury of Cumberland County has returned an indictment charging with theft of unlawful taking a disposition over 10,000 but less than $1 million. Mr. Baylor. Counselor, do you acknowledge the identity of your client, received indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motions?
Yes, Your Honor.
Okay, Mr. Barlow, I'm signing a reciprocal discovery order here that requires the Commonwealth to provide your attorney the evidence that they have. To help you prepare for your defense. We'll schedule a negotiation date for April the 21st at 9 a.m. and next court date's at April 24th. And what's Mr. Barlow's status as far as his bond is concerned? And what, is he out of state or?
Yeah, he had to be extradited from Tennessee.
It's an extradition, so that, we've got a quick thing. You need to go up and talk to Mr. Barlow about his circumstance. Thank you, Mr. Barlow.
Yes.
Thank you.
Claude Cole. Claude Cole. Officer Meredith, what case are you here on?
Sherry Cody.
Hey, will you turn your camera off until we call your case and you can turn it
Yes.
back on? Oh, Commonwealth of Kentucky versus Claude Cole. Are you Claude Cole?
Yes, sir.
You're on 22 CR 009 for sentencing. You born in 1968.
Yes, sir.
Last four digits of social security number is 6795. Your pretrial diversion was voided on February the 27th, 2025. Have you gone over this pre-sentence investigation with your client?
Yes, sir.
It's substantially correct.
Yes, Your Honor.
Okay, you're therefore sentenced to 3 years, which was the provision you agreed to before the diversion was revoked. Okay, I'm going to waive any court costs on things because of time served.
Thank you.
Thank you. Jerry Cora.
I'm sorry.
Cora. Jerry Cora.
Yes.
Are you Jerry Cora?
Yeah.
Good morning. This is 25 CR 009. You're here today for the purpose of arraignment. Did you appear in district court here? Did you have a public defender in district court? You did. Looks like you had a lawyer appointed for me, right?
Yeah.
Okay, y'all will continue that appointment. You have a right to remain silent, Mr. Courtney. You're at 25 CR 009. You were born in 1990, did you say?
Yeah.
Last four digits of social security number 3148. You have a right to remain silent. I'm gonna go over the charges with you. grand jury of Cumberland County is returning an indictment charging you with traffic and controlled substance first degree, possession of marijuana, driving on suspended operator's license, no registration plate, expired registration plates, improper display of registration plate. You understand what those charges are? Thank you. You understand what those charges are? You acknowledge your receipt of the indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motions.
Yes, Your Honor.
Yeah, I'll do a negotiation date 9 a.m. on April 21st, and next court appearance is on April 24th. Now, what is Mr. Corey's situation? Where is he from? What's his bond?
Bond was $25,000 here.
Mr. Corey, where do you live?
Burkeville.
Okay, do you have relatives here or anything?
Yeah.
Okay, who might be? Can any of them make a bond for you to get you out of jail?
No, sir.
Well, I mean, it's just a $25,000 part to prove surety. Don't have to put any property or cash or anything else. What family do you have here?
I got my wife, and then I got a sister.
Yeah. What's his background as far as this?
That's the standard.
You found anything on Mr. Corey? Mr. Stockton, do you know anything about Mr. Corey?
I just know what the officer alleged. He had 3.5 grams of meth in his truck. Said the officer ran a registration plate on a red F-150. It came back to a black F-150. He was seen reaching into a driver panel, would not comply with the officer's commands to show his hands. He opened the door. The officer thought it was 4.4 grams, but the lab report came back 3.5 grams of methamphetamine. He located a High Point Model C9 9mm silver Taurus revolver in the passenger side floorboard, and a female passenger was attempting to hide the guns by placing them under the feet.
Okay, well, we'll see him here on the 21st then. Yeah, just don't worry about it. Sherry Cote, is that right? Sherry Cote. I'm over to Sherry Cote.
Okay.
24 CR 0041. This Cody, were you born in 1976?
Yes, sir.
Last 4 digits, social security number 7839.
Yes,
You're all 20 CR 0041, and pretrial diversion revocation. What's the combo of this?
Your Honor, this is the fourth motion on this. I think Ms. Cody's been in drug court in various forms of treatment, and she had multiple violations since December of last year. We had her back here in October. She had use of methamphetamines, altering using the drug screen, different things, and I've got the officer on here to testify.
You all stipulate to the violations.
Yes, Your Honor.
If we stipulate to the violations, we will revoke the pretrial diversion. Have a pre-sentence investigation for done, scheduled hearing on April the 24th. Your attorney will be up to talk to you, Mr. Cote. Something's gonna have to change in your life. You know, I know it's not easy, but, you know, I don't want to pick up the newspaper or hear on, you know, that something's happened. Okay, so they'll be up to interview the probation parole officer. We'll see you next month. Eric Crabtree. Officer, I guess, is that the last thing you had, Officer Meredith? Is that it? You have something?
It is, thank you.
May be excused. Thank you for attending. Eric Crabtree. Are you Eric Crabtree?
Yes, sir.
This is 25 CR 0014 for the purpose of arraignment. Do you have an attorney?
Yes, sir.
DPA in district court. I'll continue that appointment in public advocate's office. Mr. Crabtree, born 2006.
Yes, sir.
Last four digits, social security number 5726. You're here for the
Yes, sir.
purpose of arraignment. You have the right to remain silent. Grand jury of Cumberland County has charged you with trespass, third degree, criminal mischief, first degree, and theft, unlawful taking or disposition. You got 4 counts on here. 1 count of lawful taking or disposition, more than $1,000 for less than 10. Counselor, you acknowledge the identity of your client receiving that way formal reading or guilty, reserving all pre-trial.
Yes, sir.
April 21st. The next court date's April 24th. Both of them are conditioned to bond.
Thank you.
Okay. Your attorney will be able to see you, sir. Mark Cruz.
True.
Mark Cruz.
Yes, sir.
Yes.
Are you Mark Cruz?
Yes, sir.
Good morning. You're on 24 CR 0014. Mr. Cruz, you were born in 1960.
Yes, sir.
Last 4 digits, social security number 3369. You're on probation revocation. What's the
Yes, sir.
combo next?
Your Honor, he's got possession 3 years, it's motion to revoke probation. And I had subpoenaed, got with Officer Garner to have a probation officer, Ryan Taylor, and he can't be here today. He's got mandatory training, so if we have to have.
What's the allegation?
Well, he's tried to get him to take a drug test on 4 different occasions, starting February the 12th. He was supposed to come into the office and submitted for a drug test on February the 12th. He didn't show. He came in on, and then he was supposed to come in the 13th. He failed to submit the drug test. And then on the 14th, he failed to return as instructed. And then he came in on February the 18th and would not take a drug test.
I haven't had a chance to speak with Mr. Cruz on this, so if we could,
Okay, well, let's just continue then to April 24th.
thank you.
Caleb Day.
Hey. Get the pop out.
Caleb Day. Commonwealth versus Caleb Day, 25 CR 0013. Are you Caleb Day?
Yes, sir.
Okay, were you born in 2006?
Yes, sir.
Last 4 digits, social security number 7613.
Yes, sir.
Okay, you're here today for the purpose of arraignment. You have a right to remain silent. Office of Public Advocacy is appointed to represent you. Continue that appointment, which was previously made in district court. That's from the previous case there. You have a right to remain silent, so that you do so. The grand jury of Cumberland County has returned an indictment charging you with wanton endangerment first degree. 4 counts. You understand that charge? Criminal
Yes, sir.
mischief, first degree. Terroristic threatening in 3rd degree. Leaving the scene of an accident or failing to render aid, and the dreaded charge of failure to use a seatbelt. You acknowledge the identity of your client, receive indictment, waive formal reading and arraignment, enter a plea of not guilty, reserving all pre-trial motions.
Yes, Your Honor.
April 21st for negotiation day, April the 24th for the next court day.
Thank
Now,
you.
any of these people that I bring up, you think that you need to discuss their bond? If you've had any discussions with them, you're free to bring it up with me, okay?
Okay, I mean, the only issue is.
But I'm not suggesting you do it on this one. Okay, I'm just making a general comment.
Okay, thank you, Your Honor.
Jeremiah Fulton. Jeremiah Fulton. Commonwealth of Kentucky versus Jeremiah Fulton, 25 CR 0015. Are you Jeremiah Fulton?
Yes, sir.
Born in 2006.
Yes, sir.
Last four digits social security number 1424.
Yes, sir.
Okay, you're here today for the purpose of arraignment. You have a right to remain silent. You have a public defender also. Okay, public advocate, come around. The grand jury of Cumberland County has returned an indictment charging you with criminal trespass, third degree, criminal mischief, first degree, and theft, unlawful taking or disposition. Or more than 1,000, but less than 10,000, is that right? Sign a reciprocal discovery order. This Commonwealth will have to give you all the information, have prepared for the test. You be here on April the 21st, 9 a.m. for negotiations. And then you acknowledge receipt of indictment. Wait for more than your aim there, plead not guilty, reserving all pre-trial motions.
Yes, sir.
You'll be here on the April 21st for negotiations, and April the 24th.
Thank you.
For next pre-trial. Dewey McCoy for sentencing.
McCoy.
Good morning, Mr. McCoy. You're here for sentencing on 24 CR 0052, 24 CR 0053. Mr. McCoy, you were born in 1982, is that correct?
Yes.
The last four digits, social security number 4837.
Yes.
Pleaded guilty to trafficking and controlled substance first degree and PFO, and second, she received a sentence of 15 years. Right. You have anything to say?
Judge, we reviewed the president's investigation report, substantially correct, not finding any kind of errors or things to be changed or clarified. We're just be seeking that the court impose the sentence as agreed to.
Okay, we'll do that. And then he is eligible for shock probation. Is he a PFO?
What?
Is he eligible for shock probation with PFO?
I don't know, I'd have to station.
At this point in time, it's moved until we can address that in 30 days, Judge, but.
Well, it is moved in 30 days unless I decide to do something else today.
Oh, well, if you would,
No,
be
I'm
inclined
not.
to do so, Judge.
No, but I'm just asking a question.
I believe that he would be eligible
Okay.
to receive it based on the substance of, based on the field.
Okay, well, y'all take a look at that. And discuss it with the Commonwealth.
Will do, Judge.
It appears to me that all of these cases are drug related, have been drug related.
Yeah, the problem is on the one case that he
Come up where I can hear you.
problem he pled guilty to, on the case he pled guilty to, there was 166 grams of methamphetamine and another 66 grams of Suboxone. We're talking about large amounts
It
of
is
drugs.
large quantity. Okay,
This was a situation where he did have co-defendants on it though as well. This,
so you think they ought to be able, like, divide it up, each one of them claim a portion of the pile, is what you're saying?
that might be a mitigating circumstance anyways.
Okay.
Yeah.
Okay, thank you very much,
There's
Mr.
his
Ford.
court costs, 660,
Do what?
his court costs.
I'm gonna waive the court costs considering the length of the sentence.
Thank you, Your Honor.
Eric Mundy. Eric Mundy. Are you Eric Mundy?
Yes, sir.
You're on 25 CR 0010. Mr. Mundy, were you born in 1984?
Yes, sir.
Last four digits, social security number 9334.
Yes, sir.
DPA continue to represent Mr. Mundy. You have right to remain silent. The grand jury of Cumberland County has returned an indictment charging you with possession of controlled substance in first degree methamphetamine, possession of drug paraphernalia, and giving a peace officer a false name or address. Counselor, you acknowledge the identity of Mr. Mundy, received indictment, wait formal arraignment and reading of the indictment. In your plea of not guilty, reserving all pre-trial motions.
Yes, Your Honor.
We set a negotiation day on April 21st. The next court appearance on April 24th. Your attorney will be up to speak to you, Mr. Mundy.
Yes, yes, sir. May I say something?
You can at your own peril. I wouldn't say anything that might be used against you. You have a right to remain silent. But you need to ask me something?
Yes, sir.
Yeah.
I was wondering if there is any way I could get out on my own recognizance, or
What's the bond?
15,000, sure.
How much? Just a $15,000 surety bond, Mr. Money, but it's hard to prove you have anybody that can come. They don't have to put any they don't have to have any cash. They just have to show that they're worth $15,000. They can tell the clerk that they signed your bond. That's a really low bond.
yes, sir. They're telling me that they have to be able to prove that they have 15,000 in property.
Well, there's no reason to have 15,000 if somebody signed a bond that doesn't have 15,000. Most people do have $15,000 worth of net worth. Who do you have that wants to sign your bond?
I can have Andre Staten or Candace Staten.
Well, Andre is a convicted felon. Yeah.
Yes, sir. Or Candace Staten would be willing.
Sir, she's not. She just doesn't own any property, she told me.
Yeah. Well,
She could.
yeah, that's all. Okay, I remember that. Well, Candace called someone to try to get them to approve maybe Hazel Anders or somebody else. Where do you live, Mr. Bundy?
231 Hurd Street.
You live here in Burkesville? How long have you lived here in Burkesville?
Almost 8 years.
How much?
Almost 8 years.
You work anywhere?
Yes, sir. I work for Nathan Thrasher doing chicken houses, and I'm getting ready to be to get on try to get on at Tyson.
Yeah, well, Mr. Thrasher signed your bond. Did you ask him to sign your bond?
No, sir.
What do you think? What's he charged with?
Possession.
How much?
I don't know that loud.
I just had a pipe here on it.
Well, just be careful what you say.
It's a residue place.
Okay, I'm gonna let you get out on the ROR because you're working, okay? But I'm gonna put you under a curfew. You
Yes,
be
sir.
at your home, church, work, or the doctor, okay? You understand what I'm saying? I'm gonna let you.
Yes, sir.
Can you hear? I'm gonna let you sign your own bond.
Yes, sir. Thank you, sir.
Okay, you have a driver's license?
No, sir.
How do you get to the grocery?
My girlfriend, her father.
Okay, well, you can go to the grocery store too. So will you be here on April the 21st at 9 a.m. for negotiation?
Yes, sir.
24th, and you're also gonna waive your Fourth Amendment rights if the police come up there.
Can you add your honor to report to probation office? He's actually on my caseload as well
Yeah.
for a one-time case. But this predates, the data for this predates his current probation.
Okay, well, you need to report to the probation and parole officer. When do you want him up there?
He can, report tomorrow,
Okay, go up to probation and parole office. What time tomorrow?
8 a.m.
8 a.m. tomorrow.
Sir.
Okay.
Yes, sir.
See you.
Sir, thank you.
Dorothy Poland. Dorothy Poland for the purpose of arraignment. Are you Dorothy Poland?
Yes, sir.
Okay, we're here today on 23 CR 0083 for the purpose of arraignment. Ms. Poland, were you born in 1985?
Yes, sir.
4 digits, social security number 6825.
6826.
6826, we'll make
Yes,
that
sir.
wrong on the docket. You here for purpose of arraignment. You have a right to remain silent. Grand jury of Cumberland County has returned an indictment of public advocacy, still representing.
Yes.
Grand jury of Cumberland County returned indictment charging you with possession of controlled substance, methamphetamine, possession of drug paraphernalia, possession of marijuana. Counselor, you acknowledge the receipt of indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, sir.
Excuse me. That's fine.
Second.
Okay, let's schedule a a negotiation day for April 21st. Next court date's on the 24th. Sign a reciprocal discovery order here. What exactly is she charged with, Mr. Stock?
It's possession, and she had about 3.3 grams of meth and various other substances that weren't tested. And she also been in NCIC since September of last year.
Okay, we'll see her on that date then. 21st for negotiation.
Discuss my bond. Is
Okay,
there any way I
thank
can discuss my bond? I don't live here and I don't have anybody to sign my
you.
surety
Where do
bond.
you live, man?
Tennessee.
Well, you've been in NCIC for that time, but we don't know. You'll need to talk to your attorney. This is a 23 indictment. It's been a couple of years, so you'll need to talk to him and he can explain where you've been or some special circumstance. He can talk to the Commonwealth, okay?
Okay.
Thank you.
I'll come to you soon.
Thank you.
Brandon Polston.
Olson.
Well, Commonwealth versus Brandon Polston. 24 CR 0050 and 24 CR 0071. Are you Brandon Polston?
Yes, sir.
And were you born in 1984?
Yes, sir, it was.
Last four digits, social security number 6513.
Yes.
We're here for pre-trial conference. What's the Commonwealth have to say?
Your Honor, we're asking the court to enter an order that on 24 CR 71, that Mr. Poston or his attorney not be allowed to distribute or disseminate the buy tapes. In this case, it's undercover buy, and then we'll turn those tapes over to Mr. Strack. And I anticipate if this case is not settled next time, that I'll be asking for a trial date. And I know you want to file a motion in the other case.
Yes, in 24 CR 50, I'll be filing a motion to suppress sometime in the next couple of days, I think.
Okay, well, we can hear that on the 24th, schedule it for the 24th. And this docket, you need negotiation day on the 21st.
Why not? He said, no, we'll just go for the pre-trial.
Let's set a trial.
Okay,
You don't
well,
want to
I was gonna give him an opportunity to look at the discovery in the case.
I mean, why would you not want a negotiation day after you see the discovery?
Judge, we've had a couple of negotiation days so far. I don't know that it's gonna change Mr. Bolson's position substantially, to be honest with you.
Well, let's set a suppression here before then and we'll
Okay.
let's get my calendar out. If he's not gonna change his position. And the suppression only applies to one case,
That's correct, yes.
so we can narrow it down that way. We can where do you live, sir?
Lebanon.
Well, Albany's a little farther away from you. What about April the 3rd? What, do you got anything on that day, Mr. Stockton?
That's Clinton negotiation day. If Miss
Well,
Gordon Anderson or Mr. Hunley can cover that day.
Judge, I am in Marion Circuit, it looks like, all day long. I'm very.
Okay. What about the 11th?
Yeah, we can just have somebody cover that day. Either I or somebody cover that.
You'll be here on the 11th
At what time, Judge?
in the morning sometime. 9 o'clock, that's 10 o'clock your time. That'll be easy drive.
Yeah, that'll work.
Okay. I like. What? No, this is suppression here. And when you say you have it, maybe by like second and third April, the suppression of.
Yeah.
I give you enough time? Yeah.
Yeah. 10 a.m. on April the 11th. We'll also, I'll rule on the suppression hearing. Mr. Stockton, I'll rule on the suppression hearing probably that day, one way or the other. If something's suppressed, you can decide to elect the other case.
We'll elect on that day if you rule on it. Next.
And you bring your calendar with you and we'll.
That sounds good.
Okay, Mr. Posey, your attorney will be up on April the 11th. We're gonna have a hearing. They're gonna try to suppress some evidence in one of your cases. And on
Yes,
that
sir.
date, we'll set your trial date, okay? Since
Okay,
your attorney said further negotiation will not help the situation very much, and we'll get you a speedy trial, okay?
Sure.
Thank you very
May I
much.
ask you a question, sir?
Well, I don't know. Your attorney probably won't want you to. What is it?
Well,
Involves.
I spoke with him about it.
Okay.
I was just trying to see about maybe getting my bond reinstated. When
Well, you'll have to have
the
a hearing on
negotiation.
that. Commonwealth objected to that.
Yeah.
So you can talk to your attorney about that, and we can have a hearing on that same day if you want to, on April 11th. You're entitled to hear.
Yes, sir.
Yeah, Brendan, I'll file something.
Okay, thank you very much. Matthew Riley.
Riley.
Hello, Mr. Riley.
Hello, Your Honor.
You are Matthew Riley. You born in 1968.
Yes, I was.
Your last four digits social security number 8553.
Yes, sir.
Your day for the purpose of sentencing. You understand that?
Yes, sir.
Have you had an opportunity to look at pre-sentence investigation report done by probation and parole?
Yes, sir, I have.
On plea of guilty possession in 24 CR 008, controlled substance, you shall receive a sentence of 3 years probated of probation parole to be supervised. And on 24 CR 0049, upon plea of guilty possession, the defendant shall receive 3 years probated of 5 years to be supervised. The sentence shall run, the two sentences shall run concurrently to each other for a total of 3 years probated for 5 years. What's the court cost in this case?
For both cases together, it's 318, sorry.
Combined.
Okay.
He doesn't have a DUI or anything.
No,
So it's what?
220.
I'm gonna combine the court costs, so it'll save you about $150. So it'd be $220. I'm gonna give you some time to pay it. The first payment, $30 will be due 30 days from the date you're released. To get out today,
Your Honor, he was accepted into drug court this morning. I spoke to Mr. Murphy. He said that as soon as he receives the order that puts him into drug court, he'll schedule orientation for the following day. So,
okay, I'll let you out as soon as the orientation happens, okay? Could be next Friday or.
well, Mr. Murphy said he always schedules it the very next day, so it'll probably be Monday or if the court would consider releasing Mr. Wright.
I'm gonna have him go through his orientation.
I understand, Your Honor.
Will you see if Mr. Murphy can take an exception if I sign the order today, if he can see me this afternoon for orientation? If he doesn't, we'll let you out at 8 o'clock on Monday morning, okay?
That'll be fine, sir. Thank you.
Okay, thank you. Good luck to you. Get back to work, man.
Thank you. Thank you, Mr. Williams.
See, Jacob Smith.
Smith.
Jacob Smith. Commonwealth of Kentucky versus Jacob Smith. 23 CR 00111. Are you Jacob Smith?
Yes, sir.
You born in 1991?
Yes, sir.
Last four digits, social security number 5078. You have a motion for child probation, Mr. Cross?
We do, Your Honor. Move for conditional discharge. This was a misdemeanor plea, and candidly, we thought that Jacob would have been out by now. For whatever reason, we've learned that he won't be out until summer. He's done really well in Adhere County. Dennis is present there today. He'd be moving back with him in Somerset. And as I say, this was just a misdemeanor plea, and I think it'd be appropriate for defendant.
You know, I hate to be the fly in the ointment here.
Speak up a little bit.
But it seems like the more we try to help Mr. Smith, the worse he does. I go back to 16 CR 20. That was a theft involving a family member. That case was dismissed. This case, when it's an assault and burglary, and we amended it to a misdemeanor, and all I heard from Mr. Cross was he was living in Somerset, he was doing great, he had a job, and everything was good. Well, he worked for a little while, then he absconded his probation. I called his employer, he was working as a truck driver, and I asked, I said, why'd you terminate him? Well, he just didn't show up for work, so he no-show, just quit coming to work. He quit coming to probation, and I just think he's had a lot of breaks. And I don't know.
How much time did you have to serve out?
The 12-month sentence, Your Honor.
What?
It was a 12-month sentence. I think it's July, I believe. I'm not quite sure.
And this is the problem. You know, Mr. Cross insisted on this misdemeanor plea. If he pled to a felony, he'd probably already been out of jail by now, but he's the one that wanted the misdemeanor plea.
Well, and that's true. And Your Honor, if I may respond to Mr. Stockton, we didn't do a felony plea because when we looked at this, it was not a strong case at all. You know, it doesn't matter what you get charged with. It's what you plead guilty to sometimes. And yeah, Jacob messed up. He was working. Then he dropped off the face of the earth for about 3 weeks. I hope he's got his feet back on the ground. But Mr. Stockton,
how many days does he have in?
He's got, he's been in since last October on this, and he had time before.
Talking about
That's it. Yeah, he likes about 2 or 3 months to finish his sentence out.
Yeah, we think it's 3, maybe 4 months. It's a pretty good while.
I'll remember this the next time Mr. Cross wants his client to plead to a misdemeanor.
Well,
be no more misdemeanor pleas. Because if the misdemeanor doesn't mean 12 months in jail, I'm not going to do any more.
Well, Mr. Stockton, I've got the power to move for conditional discharge on any case, you know, irregardless of what you and I.
Can I say one other thing, Your Honor?
Well,
no, just from a legal standpoint, I don't even know that you're entitled to shock somebody on a misdemeanor plea. That's a final judgment. I think you'd have to open it back up by Rule 6002.
I've never had that problem before, Your Honor. I don't know. It's not common, but.
Did you find out how many days he's got in? Looking at it.
Your Honor, Dennis or Jacob may know Mr. Smith is present in the courtroom. If he I know he's talked to Jacob about this, or Jacob, do you know?
Here's the thing about it. There has been a continuing pattern that doesn't seem to improve itself. You know, I don't understand. If I were Mr. Smith, I'd want to serve this time out and get out from under this thing.
Yeah, I guess if you want to be probated on the remaining part of the sentence, I don't know, if you were actually shot, that's what I'm contemplating.
How long you can only have probation on a misdemeanor for a year, isn't that right?
2 years.
2 years.
He entered this under the sign.
Your Honor, with all due respect, most people I talk to that are in the Adare County Detention Center really would like to get out.
Well, I don't know whether you've done a comprehensive survey of that place or not.
Well, I've got a pretty good history, Your Honor. I mean, it's no disrespect to anybody, but it's
But
not.
you know, most people that you talk to up there have got some reason that they're there. And
That's exactly right. That's exactly right.
Of them want to acknowledge that they should.
February 29th was when the plea was entered, so he could only be probated until February next year. And I wouldn't want him on probation on a misdemeanor because I've already had to put him in NCIC once to get him picked up the last time he violated, so.
Got 169 days, what I've got.
Yeah, he let him out, just let him out.
169 days, so he would have 140 more days. At a year.
Sounds about right, Your Honor.
Each day he didn't have as much time as I thought.
Yeah, that's that's the reason I want to know. What about letting him serve 3 more months? What would he serve on a felon? What would he have served on?
7 months, 29 days.
Do what?
Oh, felon would be 7 months, 29 days.
Yeah, well, I'm gonna let him out at the end of 7 months and 29 days. I think that's fair in between. You won't have to serve the entire time.
I'll make an order, Your Honor. Thank you.
I'm gonna let him out clean on that day, 7 months and 29 days, just like if he'd done a Class D felony. Now, Mr. Smith,
Yes,
you
sir.
kind of let blood in the water around here. You understand what I'm saying?
Yes,
I
sir.
wouldn't expect the Commonwealth to be super cooperative. So if you wanted to get on some kind of crime spree or disappearance or something, I suggest you do not do it in the 40th Judicial Circuit.
Yes, sir.
Okay? Okay.
Yes, sir.
Enter an order to that effect. Okay, thank you very much.
Thank you, Your Honor. That's all I have this morning, if I may be excused.
Wesley Smith. What do you have? So just keep it there and I'll let him. Has he seen the paperwork?
He has, he signed it, he's.
Commonwealth versus Wesley Smith. 25 CR 007, 24 CR 0072. Are you Wesley Smith?
Yes, sir.
Was born in 1993.
Yes.
Last 4 digits, number 2348. Is
Yes.
this a felony plea? Is that what it is? Mr. Smith, I have just been informed that you filed a motion to enter a felony plea. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given? Are you the same person that has been indicted in 25 CR 007 and 24 CR 0072?
Yes.
Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes.
Is your judgment impaired today in any way?
No, sir.
Have you reviewed the evidence the Commonwealth has against you? Believe you're fully informed about your case?
Yes.
You understand that you do not have to enter a plea today. You have certain rights under the Kentucky United States Constitution. Before I can accept a plea, I need to know that you understand those rights. I'm gonna go over the rights with you at the end. I'm gonna ask you if you understand. If you don't, I'll give you an opportunity to talk to your attorney. You have a right not to testify against yourself. No one can make you say anything. Right to speak trial by jury, right to be represented by counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence, right to call witnesses in favor, right to appeal this matter to higher court if you lose, and right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty and charged against you. Understand that by entering a guilty plea today, you give up those rights. Do you understand that?
Yeah.
I may consider the Commonwealth's recommendation, but I may apply a range of sentence allowed by law. I don't have to accept the recommendation prior to accepting the recommendation. I'll wait pre-sentence investigation report to be done by probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. Ms. Gordon Anderson, what is the Commonwealth's recommendation?
Upon a plea of guilty to trafficking in a controlled substance, first degree meth, in case number 24 CR 72, the defendant shall receive a sentence of 7.5 years. The Commonwealth will oppose probation. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with laws of the Commonwealth of Kentucky.
Sir, is that what you agreed to?
Yes.
Are you pleading guilty because you did commit the acts charged in the indictment as amended?
Yes.
And you're doing so of your own free will, knowing your constitutional rights. I've explained to us it's still your desire to give up those rights. Enter a plea of guilty and allow the court to fix your punishment in the range permitted by law. You understand that after entering a guilty plea today, any future convictions will be enhanced as far as the range penalty and the persistent penalty offender law. Do you understand that?
Yes.
And Mr. Bailiff, will you retrieve that signature card? I'm going to show you a signature, sir. Thank you very much, sir. Is that your signature on there?
Yeah.
Okay. I will accept the plea or pre-sentence investigation report and order sentencing on April the 24th. I'll determine what the court costs are then, considering the length of the sentence. I might very well wait.
All right, very good.
Your attorney will be up to talk to you, Mr. Smith.
Thank you.
Cody Stinson.
Stinson.
Is this the last one here? Yeah, we did. Are you Cody Stinson?
Yes, Ron.
This is 24 CR 0044 and 24 CR 0085. Mr. Stinson, were you born in 2004?
Yes, sir.
The last four digits, social security number 8596.
Yes, sir.
You're represented by Office of Public Advocacy.
I don't think so.
No.
He indicated he wanted to hire a private attorney.
Yeah, did you hire anybody?
I would like to talk to you about that. First thing, I want to apologize for last time we spoke, and I put my trust in somebody to get me a private attorney, and they've been going on about how they're gonna do it, and you obviously gave me time.
You want me to appoint you a public advocate?
Yes, sir. That's what I'm asking.
Well, I'll do that. Sometimes things
Thank
don't,
you.
sometimes
Thank you
things
very
don't work out. Okay.
Appreciate that.
Okay, well, we'll schedule a negotiation day on April the 21st, and your next court date's on April 24th, and your attorney will be up to see you, okay?
All right. Thank you very much.
Okay, thank you. Is there anybody else in the Adare County Jail?
That's what we got, Judge. We're all done.
Thank y'all for your cooperation. You may be excused. Is there any?
Thank you, Judge. Have a good day.
Got a show cause docket here. Let's see. Show cause docket. I got a diversion completion docket. Caitlin Riddle, Mr. Stockton. Mr. Stockton.
Yes.
Caitlin Riddle,
Yeah, we called her.
and we've already handled her.
Yeah, we're waiting on the Mercer County case.
Yeah, that's right. Okay, also a show cause docket. Christina Michelle Hall.
But she's been paying everyone $125 to $200 for the last.
So she's okay then?
She's not paid this month, it's the only one she's not paid.
Okay. What's she supposed to be paying? She just 125 behind?
Yeah.
Okay, issue a bench warrant. She can purge herself by paying 125. Nathan Martin. Are you Nathan Martin?
Yes.
Okay, 24 CR 0070, $70 to take care of him. You pay the $70.
Before business hours today.
You have $70 paid in about 4 o'clock today, or report to the Dare County Jail until you pay the $70, okay?
Yes, sir.
Thank you. That concludes the show cause docket. Guess the next thing we have is child support at 1. There's no child support scheduled for today. So I guess we're here at 1:15 for the civil docket. Let's go off the record.
No.
Now, correct that we had no child support today, is that correct?
Yes, that's correct,
Yeah,
Judge.
child support, all right. One fifteen docket is here. Bricker versus Bricker. Mr. Cross is trying to appear by Zoom. I guess everybody else at the state tournament's trying to get on with Zoom too, so. See if I can call him and see what the story is. Are you having trouble getting on the Zoom link? Okay, hold on a second. I'm just gonna let you get on, but I'm gonna put you on speakerphone. Okay. I'll put it right up here. Okay, say something, Mr. Cross.
Yes, how's that?
That's fine. Bricker versus Bricker.
Yes, Judge, I'm going to be withdrawing on that case. I've had to, Mr. Bricker, I thought he was in Adhere County and he's not. And so I haven't been able to visit with him personally, but I've got to withdraw. And,
Okay, before you get out, before I decide whether you can get out or not, let's catch up on where we are. Now, evidently, the hearings were held in this case in front of former Commissioner Soam. And
correct.
He resigned before he issued any recommendations. Is that right?
That's correct.
Okay. So what we're gonna have to do is get all the hearings. And my staff attorney has ordered copies of those to be made and sent to us, and we'll have to list those. What are the issues remaining that are unresolved with Cass?
Judge, the only issue is the marital residence itself.
Tell me what the issue would be.
When we had a hearing, my client had a substantial non-marital interest, and she's been paying the mortgage since Mr. Bricker's been incarcerated, which has been a substantial amount of time. We kind of held off on pushing this, given the nature of the convictions and that she and the children were victims in those cases, until he's been finally sentenced.
Has he been finally sentenced?
Yes.
How much did he get?
I think in one case he has 12 years, and in another case he may have some extra time on top of that when I haven't double checked it yet to make sure.
Mr. Cross, what is Mr. Bricker's position when you last spoke to him?
Your Honor, I don't disagree with anything Ms. Capps said, but other than, I'll supplement with this, Mr. Bricker's position is that due to the value of the marital real estate, which is a nice piece of property at Bakerton, that even recognizing some non-marital interest and where she's been living there and paying mortgage, he's got a marital interest. He's got equity. And we thought the best thing to do would just be to sell it and fuss over the money.
Judge, here's the issue on that.
Speak up a little bit.
Here's the issue on that. I don't think he has any substantial amount of equity because there was a mortgage on the property. She's still been continuing to pay the mortgage. And
How long have they been married?
bear with me just a minute. I gotta flip back through here.
Can you find out where Mr. Bricker is, clerk? Can you get online?
I think he's in West Liberty or somewhere up there.
Yeah, I think that was what Ms. Thompson said. They've been married since November of 2017, Judge.
Judge, as I'm saying, I'm not arguing with Ms. Katz, I'm just submitting.
I understand, I'm not taking this, I'm just trying to get an overview of where we are on
They
this.
did not purchase this property until 2021. They were previously married in California. They relocated to Kentucky and
So
they
this
bought
property was
property.
bought in 2021.
That's correct. And then, of course, we filed the divorce proceeding in 22. And given all of the things that have gone on,
How much did she contribute to the acquisition of the property initially?
she paid over $50,000 on the down payment.
Okay, did he pay anything on the down payment?
No.
Well, now, I don't have, I don't know if I can agree, I'm not agreeing to that.
I'm not asking you to agree. If you know anything different than that, you can tell me, and it's not testimony anyway.
Right, no, I wouldn't, as I say, they were in California, they were married and came back. There's a question of where this money came from. It's worth a whole lot of money right now, the property is.
What did the Commissioner Soam hear evidence on this? Is it included in the tape?
Yes.
So you think there's sufficient evidence in the tape for me to render an opinion on it? It's what you're saying. There's no additional evidence necessary.
There's no additional evidence or proof that needs to be submitted other than if the court needs proof of her payments of the mortgage since we had that hearing.
Well, I would doubt
I
that.
think it'd be good to have that, but we recognize she's paid for it, as she's had possession.
Okay, well, why don't you present some bank documents to that effect, and let her do an affidavit and submit that. It would appear to me that any payments that she's made would have been, probably a 30-year mortgage is,
I think that's.
so they would have a de minimis effect upon reducing the indebtedness. So the issue is the increase in value of the property since they've had it, and what interest he would have in it.
And then Judge, for judicial equity also, the fact that that's the home that she provides for the children they have in common as well as the other children she had prior to the marriage. And asking for her to be required to sell that property, especially given the nature of the charges.
What were the charges?
Oh, he's been charged with incest, rape, soliciting murder, and insurance fraud.
Yeah. Okay, well, let me review the thing. And is that the only issue remaining in the divorce?
That's the only issue, and she was trying to get the house refinanced because of the financial hardship it's creating, because she's not getting support or anything either. And then the other part of my motion was I was asking if we could get a bifurcated decree.
Sure.
So I'll submit jurisdictional proof.
Yeah, secure that. Now, I will decide whether on your you file a motion to withdraw, and I'll consider it then. Maybe we can get the thing resolved before you do that, okay?
Thank you.
Okay, take it easily. Thank you.
Thanks, Ms. Katz.
Anderson versus Anderson. Okay, I've read, did you file a written response to that?
I did,
There it
Judge.
is. Yeah, I see it. Okay, now you're asking for show cause for contempt on claiming one of the children for tax purposes in tax year 2024.
Yes, sir.
Okay. Now, I've looked at this and I checked with Megan. It appears that the order where the county, that's the reason I've asked the county attorney to be over here. The order that the county attorney was supposed to have entered included the fact that I was going to diminish the child support he would have to pay as far as back pay by 50% until your appellate result was there. How much was that?
I'm not sure if they have a total for that. I know that he was supposed to pay 100 arrears per month.
This is the order that was tendered for.
Who tendered that?
It was e-filed February 27th.
Half the obligation, Judge, was $4,952.20.
Yes, sir.
Hand me that up here. Thank you for the notice. It was just tendered the 27th of last month. Right.
Yes, that's my understanding, Judge.
Did you tender it or the county attorney?
No, I think
Is this your order or?
I think that's the order that we e-filed after, I think we consulted the attorneys and when everybody was happy with it, we e-filed it, I believe. February 26th or 7th, I believe, was when it was filed.
And Judge, I've went back and looked over the figures from back in October. It looked like in the worksheet that the health insurance was not the current one. That was what was based on in 2023. And then the income for Mr. Anderson was also based on his income for 2023. And we don't have any proof of what his current income is or what it was in October. So I went back, just double checking that, looking through everything that's been filed.
Excuse me, I've got a bond call I'm supposed to. Hello? Yes. I'm on the bench right now. Let me talk about that. Okay, I'll cover that. Okay, I'm sorry.
And the county attorney had the calculations per month. Trying to see it, $495.22, and based on my calculations, it should be $536.86, even using his income for 2023.
Judge, this is the first time seeing this, so
Well, that's $30 a month difference or something like that. We can do a wrap up on that at some juncture. How much child support did Mr. Anderson pay in 2024?
We've not.
he's not.
I've not received any, Judge.
Never been an order entered.
Correct.
Does he feel like he's got any obligation to help support the children, whether there's an order entered or not?
Judge, he does, but to get credit for child support, there's gotta be done through Frankfurt and IBD. You know, there's gotta be a number of steps. He's been waiting on this to be done since October.
Well, I'm denying your motion because he didn't support the children during 2024. And the order was, don't stand there and shake your head if you want to leave here. Okay? You understand me? Okay. The thing about it is, both sides have not given me an order until the 27th here. And now you come up at the last minute here with this 30-something. I don't expect you to decide about this other $30-something. But the order in splitting who could take the deduction was predicated on Mr. Anderson paying some child support during that time period, and he never has paid any, whether it was a written order or not. So I'm going to overrule your motion only on because of that he didn't contribute any to, but I want this finished. I want this whole thing finished. And I want, you never have played poker. You don't know what string betting is. String betting is somebody bets and then they see what's your reaction. They want to bet some more. I want this child support issue settled. Okay. And I thought I did a good deed by diminishing what he was going to pay by 50% until the Court of Appeals. But that doesn't mean that he shouldn't have felt some obligation to pay something during that time period. Nobody can think that's right. Nobody can think that's right. So while we're here today, what assurance, and I'm asking the county attorney, let's say, what assurance do you have that the numbers that someone gives you on like their tax records? You know, let's say they give you their W-2.
Yeah.
Or something like that.
We usually.
What if they do deferred comp or 401ks or any of that sort of stuff? Does that show up? The gross pay shows up on that anyway, doesn't it?
That's right. We base it off gross pay. So
Okay.
if we need updated, if the court wants to order updated information, I can run those numbers again.
Okay, well,
We just base it off the numbers.
So give it the 2024, give his 2024 return. I want to calculate it, and I want it done within 5 days from today. And then I want him to do the payment. Now, even though we're a couple of months into this thing, when he pays the back pay and we set this payment up, I will enforce this 1-in-1. You are not to claim both of these children next for this calendar year here if he is making his payments as ordered by the court. Okay, So this is 1 year that we're talking about, that he didn't contribute. So I'm not going to enforce it. And I'm going to change it. So will you draft an order and get it circulated within the next 3 days on what I've said here today, okay? So number one is I'm denying this motion because of his failure to support the children during the time period. And then I'm going to require him to pay 50% of the back pay calculation. And the county attorney's office, if you want to present any additional information, you give the 2024 information there. And it won't take county attorney's office any time to calculate this, okay? I don't want to be mean to anybody. I don't want to be disrespectful to anybody. I'm not going to be. In this case, I've tried to do what I think is right in a difficult circumstance. It was not helped by the fact when the commissioner did it, he did not do a complete resolution for you guys. He picked and chose what he did. And I think that's made it more difficult for everyone if you look at a holistic approach to this thing and trying to get it over. And, I mean to get it over and then let it enforce itself. And maybe there'll be time for everybody to go healing at some juncture. It's too much. I can't order that, but hopefully it happens. Okay. Thank y'all very much.
Matt, let me put your copy back because that was mine.
Okay. Dish room versus Spears. Mr. Cross, something soon now.
Mr. Labbitt's on the other side, Your Honor. He's not been here for several months.
What is this motion here?
I thought he
Well,
was.
this is Ted Labbitt's motion.
Your Honor.
They got the information Zoom, they got the Zoom information, but Mr. Labbitt has difficulty with Zoom sort of stuff. So he's not here. I've called the case. I'll pass over it. He can refile it, okay?
Thank you, Your Honor.
Okay. Ray versus Cowan.
Sorry.
Okay, you represent Luann Cowan.
I do, Your Honor, this cap's on this matter.
Okay, why don't you move over this way? No, you to your left. Right? You and have her get on the left of you. Okay, and then. Okay, well, never mind. It's just too difficult.
It is, we're struggling. Judge.
Okay, now you say that the respondent was arrested and charged with crimes against the party's minor child. What was that?
Your Honor, my understanding is the child was wandering in the parking lot of my client's apartment, at Rolling Acres in Tompkinsville. And initially, she was charged with some kind of, neglect or harm to the child for that, but that was dropped. During the pendency of that, this order was entered, giving custody primarily to the father. My client's having regular visitation with the child, but she's asking for it to go to an equal time.
I got you. Was there a decree in place?
Judge, these parties were not married, but
I mean, there's an order in place.
there was an agreed order entered back in June of 2024.
And what do you have to say about this?
Well, of course, we're opposed to it, one, because of the short time period, and two, they've not shown any material change for the benefit. In fact, I filed a written response. Things have progressively continued to get worse, even with her just doing the every other weekend. She's not contributing to the support of the child. The child is, now there's a social worker has an investigation with the cabinet for allegations of physical abuse.
Mr. Ray, you live here in Cumberland County? Yes, sir. Where do you live, young lady?
Tompkinsville, Kentucky.
Tompkinsville, Kentucky. Okay, and how many, is there one child involved?
There's one child, Judge.
And, so when the warrant she was arrested on the charge, it was later dismissed, correct? Was it dismissed?
I don't know if it was dismissed. I think she was entered into probation on it.
No, it was dismissed.
Was it dismissed?
Okay, so now it's been dismissed. And was there a temporary order entered by me?
There was a temporary order prior to that final order, but the final order was entered in June of 2024, where she agreed to this arrangement.
Okay, well, I'm not talking about that. We got the agreement in place. Then she was arrested. and I suspended
At one
visitation.
point, she had
Was
supervised
the
visitation.
arrest before or after the agreed order?
It was before the agreed order.
So she, in face of the in face of the arrest, she signed an agreed order to modify.
Judge, that, the temporary order goes back to October of 2023.
Okay, no, let me tell you, when was the last order signed?
June of 2024.
That was the agreed order.
Yes,
And that was after she'd been arrested.
that was after
And
she'd
did
been
you come
arrested.
in after she'd been arrested to try to get things modified?
They did not have a custody action filed between them. So I filed a custody action and we filed to establish temporary custody and have supervised visits.
The agreed
After
order-
the arrest.
The agreed order.
No, the temporary order.
Let me have the file. What was the last order that was entered? It's an agreed order, right?
It was an agreed order, final order of custody, timeshare, and child support.
That's the one we're dealing off of here.
Yes,
Okay. Now, did that happen after she had been arrested for doing something?
that was after she was arrested, after that case had been closed with the cabinet.
Okay, wait now. So, and the case had been closed.
Yes.
And she'd been found not guilty. Now, she's having buyer's remorse now on the agreement that she signed when she was facing the criminal charges and the cabinet investigation. So, was that fair?
The cabinet substantiated the allegations against her. And then the criminal charge,
What remedial action, if any, did they recommend?
I'm sorry,
What remedial action did they recommend? Did they take the child out of the home, place it in foster care? What'd they do?
they did not do that because the child was with my client.
Did they ask any additional restrictions? be
They had
placed?
restrictions in place and she was supposed to work through a case plan.
Did she do that?
As far as I understand, she did.
Yes.
And what was the resolution of that?
As far as the cabinet goes, and until this most recent allegation, there was no restriction, Judge. It just, this order was in place. She completed her case plan with the cabinet in Monroe County. It's my understanding that since we filed this motion, there's been a complaint filed with the cabinet against her.
No, Judge, there's been an ongoing investigation since, I think, the end of December with the cabinet in regards to allegations of physical abuse while the child was in her care, which was prior to them filing this
So
motion.
your
in March.
response here is where the additional allegations are
Yes.
concerned. See, I didn't know whether there were other additional allegations or not. So primarily, what are your additional allegations?
Well, there's an ongoing investigation that's been going since the end of December for physical abuse involving this child. Again, she's not supporting the child. And then most recently, as I provided to Mr. Carter, the child is coming home with burns. She had a cigarette burn to her face just from this past weekend while she was visiting with Miss Carol.
So you said cheek, that you're talking about her face.
Her face, yes.
Good. And then she's been sent individuals out without a valid driver's
Yes.
license. Who's that?
That was Mr. Ford that she resides with and has other children with.
What do you have to say about that?
Your Honor, this is the first we're hearing of an ongoing allegation since December. We're not aware of that. We are aware that as of last week, the cabinet contacted her regarding the injury to the child. She states that the one mark on the child happened from the child falling. The other did, she believes may have been ran into a cigarette. Is that correct?
Yes.
That was, presented to us in this response. I'll ask my questions.
What kind of time sharing is she getting there?
She gets every other weekend. And then the child is enrolled here in Cumberland County, and that was also an issue in the case previously, is when she had the child enrolled in Monroe County, the child was not going to school. So that's another reason we would object to any type of equal time share, because if she had the child full-time and couldn't get her to school, and there were all those issues.
Now, in the law, it takes kind of significant change circumstances.
Yes.
What are your change circumstances?
Your Honor, I would argue that the law with significant change of circumstances to change custody itself. On the timeshare, the biggest change in circumstances is she's not facing a pending
It's the
criminal
best,
charge.
always the best interest of the child.
I'd agree with
That's the
that.
standard.
That's
Yes.
correct.
But usually you have to have changed circumstances.
Yeah, I think the case, that was against her being dismissed and her completing her case plan is the change in circumstances we'll point to in our
Well, I
motion.
think that we need to, I'm not going to just up and change it because they couldn't prove something beyond a reasonable doubt. And they dismissed it for some reason. I don't know. I'm not gonna change it. But she signed the agreed order. But at the time she signed the agreed order, I'm not saying she was under direct, was she represented?
She was not represented.
She wasn't represented. It didn't look like it. Wasn't represented at the time. And she was facing criminal charges, right?
Yes,
In an investigation.
And Judge,
Go ahead.
if you could see,
I was
she,
just halfway finished, but I can wait till you talk. Go ahead.
well, her attorney, previous attorney withdrew in April, and we gave her time to get another attorney. In fact, Ms. Cowan contacted my office pushing to try to get this agreed order in place.
Okay, well, what I'm gonna do, when would you like to schedule, y'all like to schedule a hearing on this? I don't see anything wrong with the validity of the order since now, I just want or somebody to show me that in the first place, it's not the healthiest thing in the world to be smoking around a bunch of small children. Do y'all smoke in your house around those children?
No, we do not.
Well, where did she get the cigarette burn?
At my father's house Sunday night. That's when it happened.
What does they smoke around the
Yes.
children?
No, not around them. She come over, went to drop the phone and went to catch it. And that's when she hit my father's
Well,
cigarette.
somebody was in the room smoking.
My father was.
Well, I mean, I wouldn't have the children around in a room anywhere where anybody was smoking. I mean, it's a proven fact. It's not healthy for kids to have smoke. So I don't know. We can get into that. Let's take a look at Charles' calendars. How many witnesses do you think you're gonna have, Ms. Gibbs?
Probably at least 4, Judge.
Okay. What are y'all doing next Thursday? Y'all doing anything next Thursday?
Next Thursday, I'll be out of town, Judge.
Okay. Okay,
Oh, no, I'm sorry, that's,
it's the third.
uh, I will be in Nashville with the doctor, sorry.
What time you gonna have to be down there?
I have to be there at 2:00.
Well, it would push you, if we started at 8 o'clock, you got out of here at 10, you know, we might be able to do it in a couple hours, but we'll pick another day.
And Judge, I'm out the following week. I don't know, could we do
What
your
about the
next motion?
second? What about the second?
I can't the second. I'm having to cover their district all next
Okay,
week.
all right. I wonder, Megan, are you still back there? If so, I'd like to look at, see if Commonwealth versus Daly is still being tried on the 9th.
Judge, I'll be gone all that week.
Okay, forget that, never mind.
Apologize to the court, the 5th to 15th of May, I have my summer obligation to go.
Okay, let's go to the 13th. Through the 19th. What about the 15th?
Yes, I'm going the 5th through the 15th, Judge.
To the 15th, okay, we can't do it the 16th, we got a trial set for that. No,
Are we
okay,
talking
motion
May?
days on the 17th. Office closed on the 18th.
When, Mayor?
I think he was in April.
Oh, I'm sorry, Judge,
I'm in April.
I was in May.
Okay, well, let's go back then and, see what we can do on the,
On the 15th, we've got a dare circuit that day, Judge.
well, when you were looking at those April dates, the 7th through the 11th, y'all have anything available on like the night, no.
That week is spring break.
On the 11th, you be gone on the 11th? And the fifth, how about the April 15th? Were y'all April 15th?
I could do afternoon.
Got adhere circuit that afternoon.
Well, y'all are just too busy to do this case, so we probably. I don't know, I don't wanna wait a month or so. Y'all
I
need-
didn't know if you wanted to try the afternoon, the 24th, when you have your motion day after.
I'll be here that day.
Okay, well, if y'all willing to wait that long, we can schedule it for the 24th. Go ahead and put it on the 24th, have all your witnesses here and we'll stay as long as we have to, hear all the witnesses and everything. Yeah, 2 o'clock or soon thereafter is heard.
Thank you.
Yes. Thank you very much.
That's the chair.
Lone Care versus Alan Walker. Lone Care versus Alan Walker. Okay. Where's Alan Walker and others?
Judge, they do not seem to be present. This
You need to
is,
speak up just a little bit for me.
the Walkers do not seem to be present at this time. This was a pro se motion filed by Mr. Cash. I'm not sure if service was properly perfected or not. However, he's recently asked me to be retained on this case and stand up here with him. And it's simply for a writ of possession. He purchased a property at a master commissioner sale, roughly October 25th. And the parties have not vacated the premises, and he is just simply asking for possession of that property.
Well, it looks like he's got a certificate of service on here where he served at
does.
the last known address.
It does, but just because I didn't send it, I couldn't kind of vouch for any authenticity there.
Yeah. You raise your right hand. Swear the testimony you're about to give us the truth, the whole truth, nothing but the truth.
Yes, sir.
Lower your hand. State your name, please.
Jason Cash.
And Mr. Cash, I see on here that you certified that you mailed a copy to the last known address of Alan and Carol Ann Walker. Is that correct?
Yes, sir.
Did you put it in first class postage?
Yes, sir.
Okay. Did you receive it? Did you have your return address on it?
Yes, I have not returned.
Did you receive a return?
No, sir.
Okay, now what relief are you seeking for your client now?
Judge, Mr. Cash simply just wants to take possession of the property.
Okay, well, now he can't go over there and take possession of it. So are you suggesting the law would, if you submit an order to me, would have the sheriff to go over and
Yes, Judge.
just
that would-
seize them of the property and set their stuff out in the roads? Is that the way it works?
Well,
I mean, that is the way it works. And
I do believe so, but if it could just be a peaceful transition.
well, they wouldn't need you if it was gonna be peaceful.
Well,
You
we're-
got to talk all the lawyers out of work here. If everybody would do reasonable, peaceful things, we could just put the lock on this place.
We're hopeful.
Yeah,
We're
hope
hopeful.
springs eternal. Well, you hadn't practiced as long as some, you've been around as long as Mr. Little is, you'll lose some of the hope that you have now.
Oh,
So,
no, he still looks pretty hopeful up there.
yeah, it's just fooling you. You draw me an order and I'll sign it to request the sheriff. And I want you to give in order, set the statutory authority. This is a layman's motion, so it doesn't, well, Megan, my staff lawyer, has been looking at this somewhat in anticipation of this motion. Okay,
Yes, that'd be good, Judge.
so give us an order and we'll do it, okay?
Thank you, Judge.
Okay, thank you, sir. Good luck, yeah.
Stop.
Okay, Jimmy Ray Thrasher versus Rebecca Annette Thrasher.
They're supposed to agree to work and
Yeah, that was over a password to Wi-Fi. I think that's been done, okay. Cole versus Cole Gray. Okay. Hey, what do you got, Mr. Little?
Your Honor, good evening. I represent Ruth,
Gray.
Good afternoon, it's not evening yet. Hopefully.
I represent Ruth Cole, Ruth Gray. This case was filed by David Cross, and we filed an answer. I think there he is on TV. And we filed a motion for summary judgment in order of sale to the Master Commissioner of indivisible property. Mr. Cross filed a petition for divisibility or trying to divide it. I looked up the law on this, KRS 389A030 creates a presumption of indivisibility. And there's a case that says if a party claims divisibility, they have the burden of going forward. I've cited that case in my motion. He presented no evidence, and he can't present any evidence that it's.
What kind of piece of property is it?
It's a large piece of property with a house.
How many acres?
It's 167 acres approximately, more or less.
Okay, with a house located on.
Right.
Ma'am, are you involved in this case? That's probably a good move, so.
The terrain varies. There's some creeks. It cannot be divided equally or equal value. It's impossible. And my client
These
objects.
people are related to each other at one time. Are they married?
They were married. They were divorced in 2001.
And she has resided on the property since then, or who's resided on it?
I've lived on it since.
Mr. Cole, let me do the talking unless we,
Mr. Cross is here. You can't see, you can see him back there. See him? Okay, Mr. Cross, give me your client's side of the story about.
Your Honor, I'll be happy to. This is a tract of about 167 acres on Whetstone. Mr. and Mrs. Cole were married. Mr. and Mrs. Cole lived on Whetstone together for, I'm estimating, 15 years. They divorced 24 years ago. For whatever reason, they did not deal with the real estate in the property settlement. So it's still owned 50-50 in survivorship. Now, what has happened is Ms. Cole contacted Mr. Cole and said, I want X number of dollars for my 1/2 interest in the property. At that point in time, when Mr. Cole came to see me, I filed a petition for partition, seeking that to have the court appoint commissioners to try to divide this property. My worthy adversary, Mr. Little, has made one statement I've got to argue with vigorously. He says the property can't be divided. 167 acres and a house, it's not anything extra. Of course it can be divided. Of course it can be divided equally. So we have filed a response.
The issue, can it be divided without materially altering the value of the entirety?
Right. And we feel like, Your Honor, as I said, we beat him to the courthouse, so to speak, to file this. What I would request that the court do at this point in time, because, Your Honor, Claude Cole's standing there in front of you. He's 80 years old. He's lived there for 40 years. And what Mr. Cole wants to do is live out his days on Whetstone. And if this is sold by the master commissioner, that's not going to happen. But if we can figure out a way to pay Ms. Gray for her interest through a third party purchasing her interest, and we have some people who are interested